proceeding, but amount is only 1,51,200. It is below limit. I have submitted the circular and order copy of the similar order copy to.
Just tell them. Yes, please. It's covered by this judgment.
It's come under circular. It's a below 1 crore. And appeal amount is
below the monetary limit.
Appearing on behalf of respondent, my name.
The appeal is treated as withdrawal.
Lordship.
Right.
Obliged lordship. Weekly list item number 2. Weekly list item number 2.
None appears dismissed not possible.
Weekly list item number 3.
None appears dismissed not possible.
Appearance of union noted, my lord.
All right, sir. All right.
No instruction, my lord. Item 3, my lord, no instruction.
All right. Counsel petitioner states he has no instruction. Item 3.
Give privilege.
Weekly list item number 4.
My lord, I am appearing on behalf of Mr. Panda in item number 4 and 6. My lord, the matters have become infructuous, my lord.
All right. All right. Thank you. Counsel petitioner states that the matters of this matter is infructuous. Disposed of as such.
Unanimity has been noted.
Yes, please.
Weekly list item number 5.
My lords, I am appearing on behalf of Mr. Sanjay Acharya. My lords, I have instruction that we have no instruction in this matter. However, a liberty may be granted.
No. It's a 2006 matter, sir. No liberty.
Then, your lordship, then we may be kindly permitted to withdraw it with liberty.
All right. Counsel the petitioner seeks leave to withdraw this petition. Dismiss.
I'm for the opposition. My lord, in this case, the railway has been brought on the Lord in ASG and I was instructed to appear today.
All right.
Weekly list item
I am
number 6.
holding the wakalat, that is why I submit.
All right. All right.
Gratefully, your lordship.
Weekly list item number 6.
Same as item 4, my lord.
All right.
Weekly list item number 7.
No instruction, no instruction.
Counsel the petitioner states he has no instructions.
I'm for the opposite party.
All right.
Weekly list item number 8.
Yes, may I please, my lords?
Yes.
This item is identical with item number 22 of today's supplementary, 23 of today's supplementary. Whereas both are
Then.
different periods, same issue involved. Whereas
Yes.
your lordship, by order dated 6/9/2007, while issuing notice, I directed the parties to file counter and agenda. Pleadings are completed, counter agenda filed, and your lordship have also protected that no coercive action, which is also operating till date. Whereas the case is the synopsis, let me highlight it for lordship.
Your lordship, this is appealable order, your lordship.
Appealable order, my lords knows every assessment
It is an assessment order, and many factual aspects have to be considered, your lordship.
Despite of the fact that order is appealable in 2007, your lordship, while applying judicial mind, my lords, have directed not to take coercive action and directed complete pleadings so that matter can, because the matter touches to the root of jurisdiction. Because as my lords knows, unless there is purchase and sell, which goes to root of entry 54 list to my lords, unless there is purchase and sell, state has no power to levy tax. But it's a case I am engaged in business of financing the commercial vehicles. Loan financing cannot be brought under levy of tax. And your lordship understood that, the very question. And I am taking your lordship's attention, directly, to the counter filed by opposition, how they have responded to a petition. Your lordship may kindly see first to the counter, then I will tell my case, with great humility, Whereas page 63 of the counter, just I am moving in the reverse direction with your lordship's kind permission. Page 63 of the counter.
Yes.
Page 63. Well, so what has happened here? I am a commercial associate, my lords, of SDFC Bank Limited. My lords, just let me brief, then I will take your lordships to that, my lords.
Yes.
SDFC Bank, by virtue of an agreement which I have entered into SDFC Bank, my lords, I have to arrange customers, proposal forms along with all profile of the borrowers, my lords, and those after due scrutiny, my lords, with my recommendation will forward it to the SDFC Bank for sanction of loan, my lords. Whereas what has happened, certain papers which are there in the document that carries hypothecation.
Higher purchase.
Higher purchase.
Higher purchase.
So without lifting the veil, what the actual nature of transaction, because the ward cannot decide the liability belongs, whether it is this higher purchase or itself, because higher purchase means going by constitutional bench judgment of this installment India Millers, higher purchase is beyond the levy of the legislature, power of the legislature to impose tax. It's only the parliament can do, and by 46th amendment, of course, that situation is over because it can be treated to a deemed sell. Because those are not the situation here. But here, what I will submitting, you will also kindly see paragraph 13. Paragraph 13 at page 63. That the order of assessment for the period involved in the present writ petition are based on fraud case report submitted by sales tax.
Page 60, you're arguing writ petition civil 8661 of 2007, I presume.
I am pressing for paper book by law. I have submitted paper. I believe
that is page 58. I'm subject to your lordship's correction. Page 58,
yes.
paragraph 30.
It starts from page 50.
All right.
It starts from counter affidavit starts from page 58. And relevant is para 13 from page 63 minus.
Yes.
Minus.
Para number?
Para number 13.
That is at page 58.
Your lordship may kindly see from the midst of the paragraph, the admission of the fact that, my lords got it, my lords? The admission of the fact that the petitioner is liable to pay entry tax on the vehicles purchased from outside the state clearly indicates that the petitioner has been carrying on business of hire purchase of the vehicle by itself and through the finance of SDFC Bank. Separate assessment proceedings has been initiated against the SDFC Bank. Now, my lord, your lordship may kindly see page 80. Now, they say that against SDFC Bank, separate assessment proceeding has been initiated, my lord. Now, your lordship may kindly see page 80. Because this is a service contract entered into between the present petitioner and SDFC Bank. My lords may kindly see page 80, services. Because I think I am clear now. Services, para one, serial number 1 of the contract. Yes, services.
Correct.
This commercial associate,
yes.
Because commercial associate shall interview prospective customers and make a preliminary assessment based on predetermined criteria supplied to the commercial associate by SDFC Bank. The commercial associate shall forward only those applications that meet the predetermined criteria along with letter of recommendation. That's commercial assessment before your lordship present petition on the Then he shall obtain all necessary supporting documents required by SDFC Bank as per Schedule 2 here too, shall submit the complete application to SDFC Bank or its authorized representative along with all support documents. The commercial associate shall ensure that where photocopies of documents are said to be rendered by the applicant, such copies are duly authenticated by verifying the original. Then Millers has responsible collection of payment Millers. On behalf of them, I am authorized to make collection Millers of EMIs. Then next page Millers, the commercial associate shall, upon delivery of the vehicle to the borrower, will collect a copy of the invoice and forward it to SD. Because all these things I am authorized. These are essentially this is a service contract. And how it is service and what I am going to get, my lords. Your lordship may kindly see consideration page 82. What is the consideration and billing for the work which I render, my lords, the service I render, what I am going to get. The commercial associate shall bill SDFC Bank for the services rendered as set forth in Schedule 1 attached here to, and made a part thereof. Payment to commercial associate for the services would be made as mentioned in the said schedule. It's the entire gamut of millers, the case which is made out according
No,
to
Mr. Sahu, are you saying that in law,
My lord.
the appellate authority or tribunal is not entitled to see all these clauses in the agreement?
Absolutely.
They cannot, they should not. Law prohibits the appellate authority from looking into this agreement.
No, absolutely. Because
So they can interpret this agreement, they can interpret the judgment of the Supreme Court, they can interpret the statute.
Because only it is after 14 years, therefore
That's
I
all
wanted
right. If that interim order will continue, sir,
My lord,
and we'll make it time bound.
My lords, your
All
lordship. Because for other 2 periods also matter is pending for the tribunal of the very same petitioner, my lords. And I have a judgment of my lords, filter co, where Supreme Court has said, my lords, that if there is any adverse order by a superior authority where you are going in appeal, well, Honorable Supreme Court, I don't know what is essentially the theory is, my lords. If there is an adverse order by the superior authority, then it is better, the appeal will be futile. So therefore, Supreme Court said that it is for the High Court to decide. Of course, right or wrong. Left to your
Ultimately, it will come to the High Court, sir, in a different route.
Right. Ultimately, I will have to approach your lordship.
Correct.
Again with another round of battle.
Correct. The challenge in the present petition is to an assessment order. No, while issuing notice in the present petition on 6th September 2007, this court had directed that no coercive action would be taken against the petitioner. That interim order has continued till now. Having heard Mr. Jagabandhu Sahul, and senior counsel for the petitioner, and Mr. Sunil Mishra, and standing counsel for the department, the court is of the view that the petitioner should first exhaust the statutory remedy of an appeal against the impugned order of assessment. Accordingly, it is directed that if the petitioner files such statutory appeal not later than 7th March 2022, accompanied by an application for condonation of delay, citing the pendency of the present petition as a reason for the delay. Such
And also
application.
waiver of deposit, your lordship may kindly say. Because
No.
unless I have to pay now,
No.
Honorable Supreme Court has also said
Such
so.
application will be considered on its merits by the tribunal.
By the first
The
appellate
interim
authority.
order passed by this court on 6th September 2007 will continue till such time the appellate authority passes an order in the application for interim relief to be filed by the petitioner along with its appeal, provided such appeal is filed within the time indicated herein before. It is made clear that this court has not expressed any view on merits. This order should also not be construed as accepting the prayer of the petitioner for any waiver of pre-deposit. If such a prayer is made, it will be for the authority concerned to deal with it on its merits in accordance with law.
Your lordship, before first appellate authority.
Yes, first appellate authority.
My lord, your lordship, I have heard.
All right. No, I've said appellate authority.
Your lordship.
Perhaps may I pray the appellant being from Kolkata, at least perhaps the time be extended given 4 weeks, perhaps, so that I have to perhaps
No,
arrange.
so I've permitted you till 7th March, sir.
I think it's
7th?
2 weeks, perhaps. So
All right. 21st March, sir. 21st March.
my obliged and original order may kindly return.
Yeah, the original of Annexure 1. No, sorry. Annexure
Annexure 6, your lordship.
Annexure 6 be returned subject to being substituted by an attested photocopy thereof.
Same order may kindly pass for item number 23 of the
23.
Same order in 23. All right.
Supplementary list.
All right.
Obliged, your lordship. Grateful.
Right.
Weekly list item number 9.
Once I am for the management of Bhubaneswar Development Authority mailers. The workman was working as mailers NMR. There was a policy decision way back in the year 1994-95 to regularize those have continued for quite some time. Accordingly, the petition, the opposite party was regularized on 25/4 to 1995 mailers. Then mailers, there was no as security guard mailers. Very important is that as a security guard, she was regularized. Then mailers, there was no pay scale available so far security guard is concerned. We inquired from the government. There also there was no such mailers scale. But any inadvertently or advertently, minors, that he was extended a scale of pay of 825 to 1100 minors. Subsequently, the authority minors, in comparison of all these three, in consideration of 33 others minors, similarly situated persons, those who have been designated as minors security guard, they reduce the scale. Reduce means they revise the scale. Rather, it is they specified a particular scale of pay for the security guard of 750 to 940 minors. So now they have been getting salary on the basis of that 750 to 940. Admittedly, it is a mistake in the part of the authority minors. They have given a mistaken minors scale and they revised it. They have been getting it. Some of them have come before the Honorable High Court, and the opposite party has gone to the industrial tribunal. The industrial tribunal have come to a conclusion, it's kind of a glance to that, come to a conclusion that she is entitled to that scale once it is given. Referring to a judgment, my lords, I will place that portion of the judgment basing upon which the learned court, labor court has proceeded, that is a page 17, my lords. Page 17, they have referred to a judgment. Employees, I may quote read that paragraph, minutes.
Yes, yes.
Employees working in several services of thermal power station of Central Electrical Authority administrative control of the power station taken over by National Thermal Power Corporation in 1978. Fixation of last drawn basic pay in the year 1980 by CE is illegal. Any reduction in the basic pay employee on the basis of the order of OEA also not permissible on the basis of the above principle of law. So what happened in that case?
How old is this man now, sir?
Minutes?
How old is this workman now?
Now she will be.
No idea.
No, I may get that information.
We still have to argue the case. We still have to give a judgment. No facts. Nobody. You don't know facts. We don't know facts.
All right, minutes. I'll get that over.
No,
phone
no,
also.
no. So we'll adjourn.
I will get that. No, minutes. I'll get that over phone also.
We pass it over. You find out over.
I will get it over.
Yes, yes.
I'll get it over.
Quick list item number 10.
Item number 10, 11, and 12, my appearance be ignored, man. Reviewing the matters have been taken away from me.
Mr. Ratha states that the petitions have been taken away from him. None appears for the petitioners. Dismissal, non-prosecution.
Item number 13.
Northwest, your lordship. Item 13, Northwest.
Northwest.
Appearance of OP. Opposite party appearance, and Union of India.
All right.
Item number 14.
None appears. Dismissal, non-prosecution.
Item number, weekly list item number 15.
16, my lord.
15, I have no instruction.
No instructions.
Weekly list item 16.
Item 16, my lord. My wife is seriously ill in blood cancer, my lord. I am bedridden in my house. Oxygen,
Whom are you appearing for,
is
sir?
going on. Time kindly be allowed.
Whom are you appearing for, sir?
My lord.
You are appearing for whom? For the
Appearing
petitioner?
for the petitioner, my lord.
What is the petition number, sir? Can you
Society
tell us?
advocate.
Petition number?
Item number 16.
No, no. Petition number.
WPC number, my lord, 3607 2008, which I would minus 449 2009.
Where is your paper book, sir?
My
Where is your paper book? There are two matters of yours.
Two matter, my lord.
What is the matter about, sir?
Sir, seriously ill, my lord.
What is the matter about? What is this matter about?
Matter, one matter is, my lord. Challenging the illegal injustice and arbitrary award dated by 2007 in the industrial disputes case number 2 of 1994 passed by the Laurent S.K. Mahapatra, presiding officer, Labor Court, Bhubaneswar.
Has the opposite party been served, sir? See, check out. Vishwanath Dash. But no notice has gone in this one. No, notice is gone. This one Vishwanath Das is appearing. What has happened in the Indian award? So let's just see that. It's the counter. There is stay here. You already attained the age of superannuation.
Yes. 25% grant. Back values.
Yeah.
In case of superannuation compensation.
Sir, 11th September 2013.
My lord.
11th September 2013. Kindly read that order.
Order 2 of 1994. Yes,
1 minute, sir.
Annexure 4, my lord.
No. Okay. Are you able to hear me, sir?
My lord.
Are you able to hear me?
I want to.
Are you able to hear me, sir? Can you listen to me?
Listen.
Am my voice audible to you?
Sir, time kindly be allowed.
Sir, kindly tell me, are you able to listen to me? Can you hear me? Can you hear me, sir?
My lord.
Can you read the order dated 11th September 2013? Passed by this court.
Labor court.
Sir, kindly listen. This court's order dated 11th September 2013. Can you read that order, sir? This court's order.
Order to Annexure 4, my lord.
No. Are you having a copy of the order passed by this court? Order dated 11th September 2013. This court's order dated 11th September 2013. Are you having a copy of that? No.
Just give him that copy. We will give you that copy, sir. Kindly read. Kindly read the order loudly, sir, into the mic. Kindly read that order, sir, loudly.
Party.
Sir, kindly read it loudly into the mic.
My lord. 11 August, September 2013.
Yes.
And since the opposite party appearance for the EG to what the supervision in the meantime, Lawrence Council for the petitioners management is directed to what amount come to be paid to the rent in the full and final settlement of our court and put up this matter to 7th 10th June 2013 man SC Parija, my lord.
What is the amount payable under the award?
My lord.
What is the amount payable under the award, sir?
My lord, time kindly be allowed to settlement the matter between the OP and the society, my lord.
Mic is switched off.
Anyway, he doesn't listen. Sometimes I'm losing my voice, so I request Justice Patnaik to do all the difficult tasks.
He is unable to.
No, and invariably it happens when I ask a question, the council is blank. But when he asks, they're able to understand. So that is how it is. Yes. What is the amount payable, sir, under the award?
Sir,
You want to read the last paragraph, page 24.
23. My lord, sum of rupees 65,000 to 65,000.
Right. All right. You see, the present petition challenges an award dated 14 September 2007, passed by the Labour Court in industrial dispute case number 2 of 1994, where the term of reference referred for adjudication was whether the dismissal by the petitioner management of the respondent workman bracket clerk with effect from 1st September 1979 was legal or justified. Full stop. The Labour Court has in the impugned award held the dismissal to be illegal and has directed the management to reinstate the workman in service forthwith and also pay 25% of the last pay as back wages for every month since the date of retrenchment till the date of his reinstatement. Further, it has directed that if the workman had reached the age of superannuation, the management is to give a lump sum of rupees 65,000. Paragraph. On 11th September 2013, that is more than 5 years after the writ petition was filed, it was noted by this court that, open quotation, since the opposite party workman has already attained the age of superannuation, in the meantime, learned counsel of the petitioner management is directed to take instructions as to what amount can be paid to the workman in full and final satisfaction of the award. Unquote. After that, the matter came up for hearing on 8th September 2017. And was not listed thereafter. Paragraph. Clearly, the management has not been able to come out with any figure for settlement of the dispute. Paragraph. With the workman having superannuated long ago and the amount required to be paid by the management just rupees 65,000, and considering that the workman had rendered services to the management since 1974, the court does not consider this to be a case fit for interference at this stage under Article 26 of the Constitution. The petition is accordingly dismissed. What is the second matter? Let's just see that. Cooperative tribunal. We've already succeeded in that connected matter. No? Hmm. The second petition, you said this challenge is an order dated. This petition challenges an order dated 30th September 2003 of the Cooperative Tribunal Orissa, allowing the appeal filed by the respondent against an order passed by the Registrar of Corporate Societies by the DCIG cum DRCS, DIC, Jagatpur in dispute case number 43/1999-2000, whereby the case was allowed in part and the respondent was asked to pay the petitioner society rupees 10,16037 as interest, no, as principal, and which includes the principal of 5908.35 and interest at 18% per annum to the society. Paragraph by the impugned order, the tribunal held that the court below had not recorded a brief memorandum of evidence of the parties as required under Rule 78 of the Orissa Cooperative Society Rules, 1965, and that except for an audit report, there was no material to show that the society sustained losses on account of the laches of the respondent or that he misappropriated any amount. Paragraph. Considering the on perusing the impugned order as well as the petition, the court is of the view that the impugned order does not call for interference, and the amount also involved is not substantial to warrant such interference. The petition is accordingly dismissed.
Weekly list item number 17.
Item 17, my lord, calling to file fresh representation before OP1, my lord.
All right. Counsel to the petitioner wants to file a fresh representation.
My lord, the
OP
representation.
number 1 and accordingly seeks to withdraw this petition. The petition is disposed of, is withdrawn with liberty is paid for.
Both the cases.
All right, both cases.
Weekly list item number 18.
With all respect, may I submit, my lord, inadvertently, my lord, this is a single judge matter. OLR matter is single bench matter.
According to the counsel of the petitioner, this is a matter before a single judge. But the service has not come back, sir. No such address.
That may be, but I have filed at the right point of time. It must have gone, but up-to-date information may not be there. But I have filed my own requisites, everything, my lord. In my file, it indicates.
No, the requisite filing is one thing. Service being effected is another, sir. These are two different aspects. One is your filing requisite is one aspect.
No, 2008, it is filed, my lord.
I know, but it has not been served, sir. All right, filing requisites is one thing. Service of notice is another thing. No? That service is not effected because there is no such address.
No such address.
And this is in 2008. We are in 2022. So no point in keeping these matters pending.
So, let it be before honorable single judge.
Doesn't matter. You have the correct address. You show us now.
I take instruction whether that fact is.
Now, not now, sir. You should have been following this up in 2008.
But kindly see, but I have to just check up, my lord.
What is the matter about? Let's see that.
The OLR matter, my lord, because very
sir,
small point is
One
concerned.
minute. Now you're fully ready with the matter, correct?
No, not ready.
1 minute, one
Not-
minute. Just
not
wait.
ready. Not ready.
Wait.
Not ready.
Since you're fully ready, we'll might as well hear you today.
OLR matter.
This is 10 years old. Before 2010, this matter. So all matters will come to this only.
No, this division bench, assignment is division bench. That I have to point out before my lords, what can happen. All division bench matters up to 10.
Board of Revenue, I think all Board of Revenue matters are coming here only.
Yes.
No, arising OLR matter. This is OLR.
Board of Revenue matters are coming here only.
This is OLR matter, not Board of
You
Revenue.
Carry on. It's all right. You carry on. Tell us what the matter is about.
Question is good because if I lose my lord, I would lose a forum. WA cannot be filed. That
All
is
right.
anxiety mine.
All right.
Your lordship may kindly see. Your lordship is
Your main
arguing to
contesting parties have not been served for the
My
last
lord?
14 years. Your main contesting parties have not been served, sir, for the last 14 years.
must have been solved, my lord. But the
Sir, just
noting, my
look at
lord,
the file.
check up, my
Just
lord.
look at the file. Look at the file.
With correct address, I have to file, my lord. It
Not
has
now,
not been-
sir. Not now. That should have been done at the
For
appropriate
a
time.
small thing, my lord, coming from Andhra Pradesh, migrated Rayagada, I purchased a property. Vendor having purchased, my lord, taken money, again included, this is the sole modification is required as a subject matter of the writ application.
Yes. This is
And that is-
Tahsildar's order. 18/10/2005. That's an appealable order, no? The Tahsildar's
Can I
order
see-
must be an appealable one, Mr. Manti.
Yes, my lord.
Ah.
Let me clear.
One,
Annexure 3.
one noting is there, the lordship notice issued to OP number 5 and 6, returned unserved due to want of time. Sometimes
Want of time?
time, this is like
No,
this.
no, you're reading conveniently what you're reading.
No.
The address is not complete. There's no such person. That's
No,
the-
I am reading from this.
There are how many respondents?
I am reading.
How
order
many
number
respondents?
two.
How many opposite parties?
Opposite parties, my lord. Something like that.
4, 5, and 6.
3 up to 3 is state. 4, 5, 6.
Anyway, this is an order of Tahsildar which is challenged. It is appealable order.
So,
Tahsildar's order is an appealable order, sir.
one thing just I would bring to your lordship's kind notice, your lordship may kindly see. I purchased the property. My lord, the ceiling was dropped. There was no ceiling proceeding. I purchased. My lord, that is the only land at Rayagada, my lord. My other brothers, my lord, they have taken all land at Andhra Pradesh, my lord.
What is the reason for the delay,
Your
sir?
lordship may kindly see what are the just I am bringing to my lord's notice. I do oblige if your lordship disposes the matter. There is nothing. Your lordship may kindly see. Annexure, page 18, annexure 3. Page 18, annexure 3. And the Board of Revenue's order, I am nothing to submit. Kindly see, while implementing the Board of Revenue's order, the Tahsildar what has done, my lord, the somebody on behalf of the vendor appeared, said that I want to retain this much of 41 acres of land. That is own land. But the purchase has been made by me. He is supposed to include in his list. This is the only modification required. When he has sold, my lord, 1 acre something property, my lord, in his list, he is to include that. That is to be deducted from his list.
So this Tahsildar's order, Annexure 3 is appealable, correct?
Yes,
Your lordship may
what
follow
he has
my-
submitted, that Board of Revenue order is not impugned. He is challenging the Tahsildar's order and he can challenge it in appeal. That is the order of 2005. I think that's
the petitioner states that it is
I'm
agreed
just
by an
giving
order
it.
dated 18/10/2005
All
passed
right,
by the
all right.
Tahsildar. Rayagada, dependency of the present petition. The appellate authority will consider such appeal on its merits.
Yes.
In such event, the interim order passed by this court on 19/1/2012 will continue till such time the appellate authority disposes of the application for interim relief to be filed by the petitioner along with such appeal. Court clarifies it is not expressed any
One
view on
prayer,
this.
man. One prayer, man. One prayer. Along with the petition for limitation, because they would.
So you're not listening to what I dictated. You apply for a copy, you will get it. All this is there in that.
Yes. Yes.
Weekly list item number 19. Item number 19.
None appears dismissed and not prosecution.
Weekly list item 20.
On behalf of Mr. B.S. Das, I pray for withdrawal of this case.
Counsel, the petitioner
Memo
seeks leave to withdraw this petition. Dismiss this withdrawal.
Weekly list item 21.
21 Lordship, no instruction.
Counsel, the petitioner states yes on instructions. All right.
Weekly list item 22.
May I please, Your Lordship? The impugned order is at annexure 1. The punishment imposing deduction of 1% from the pension has been set aside by the tribunal. That was done in the year 2007. Now we are in 2022.
Yeah. You say, considering the passage, long passage of time and the nature of the impugned order of the OET, which concerns the reduction in pay in the pension of payable to the opposite party, the court does not consider it appropriate to interfere at this stage. The petition is dismissed.
Weekly list item 23.
Item 23, Your Lordship, became infectious, Your Lordship.
All right. Counsel, petitioner states become infectious, disposed of as such.
Weekly list item 24.
None appears dismissed and not prosecution.
Weekly list item 25.
None appears dismissed.
My lord, in 25, item number 25, my lord.
Yes.
That is appeal, my lord.
Yes.
The honorable single judge.
Yes.
And the notices are issued, however, they are back without any.
All right. List before a bench. Okay. List before a bench of which Justice Patnaik is not a member. On 16th March.
Weekly list item number 26.
None appears dismissed and not prosecution.
Weekly list item number 27.
May it please, Your Lordship. My lord, opposite.
Yes.
27.
Yes.
27. Yes, sir.
My lord, opposite party number 3 had got a lease from the government of Orissa, and he had sought to transfer the lease in favor of the present petitioner. Well, the lease was allowed. Well, I'm sorry, the transfer was sanctioned by the government. Your Lordship, kindly see.
My lord, I am appearing for the OP number 3, my lord.
Yes.
I was appearing, my lord. This is a very serious case where I have, my specific case is that compromise decree on basis of which the petitioner relies, that has been obtained behind the back of the petitioner by impersonation and by playing fraud, my lord. And the very same issue is now pending in CMP 1580 of 2016, my lord. And further, we have not given any permission to transfer the land. That is also my specific stand in the counter, my lord. In the meantime, OP number 3 expired and they have not substituted. But they are also not appearing in the CMP. We moved the quote below that it is obtained by fraud, by impersonation behind my back. That is the subject matter of challenge in CMP 1580 of 2016, my lord.
Mr. Mishra,
my lord,
if when did OP number 3 die, sir, expire?
I have filed an application for substitution
In 2016, and he is the co-brother-in-law, my lord.
They have not filed any counter, so they cannot have. My lord, let's kindly see, you have filed application, substitution was allowed in notice had been issued on 4/11. I filed application on 4/11/16, and petition, the notice has been sent. Notice has if my learned friend intends to appear, then okay, but he has not filed any counter. I do not know how, on what basis he is submitting, because I do not know. And the government itself.
I have already, on behalf of OP number 3, I have already filed the counter. The preliminary counter is there on record.
No counter copy has been served on us.
Anyway, what is the matter about, sir?
OP number 3. OP number 3, when he was alive.
No, Mr. Mishra, he says there is a CMP pending on the issue of fraudulent transfer.
I do not know, because whether the notice has been issued or not, because I do not know.
Yes, my notice has been issued.
I do not know.
They have not appeared. That is pending. 1580 of 2016.
Because they have not filed any counter, so I do not know anything about it. I'll have to
CMP is directed against what, sir?
My lord,
I do not know.
My lord, I moved the court below for recall of the order because that has been obtained by fraud. That was, though, admitted that petition is maintainable, but ultimately rejected. Now the CMP is pending before this honorable court. That is CMP 1580. And the present petitioner is the sole opposite party there.
No. So the present petitioner sought transfer of ownership on the basis of the decree in TS 214.
Yes, my lord. If your lordship may look into the annexure 4. That is very interesting, my lord. Annexure 4 series.
So, Mr.
It was
Mishra,
often behind my.
Mr. Mishra, suppose we clarify
Yes.
that the General Administration Department will re-examine the issue depending on the outcome of the CMP. That serves your purpose.
Yes, my lord.
All right. You say the petitioner has questioned a letter dated 8 June 2009 of the Director of Estates.
Because
The
permission
General Administration Department, Government of Orissa, declining the petitioner's request in the application dated 15th December 2008 for transfer of ownership of lease plot number N-6/231 from Lakshmidhar Tripathi, bracket OP number 3. Right in the beginning, the application for substitution is allowed. OP number 3, bracket. Stop. The above application was filed by the present petitioner on the basis of the decree obtained in TS number 214 of 1998. The court of the civil judge.
My lord, may I interfere for a minute, my lord, because the component decree which was obtained much later. The sanction of the government was accorded way back in the annexure 2 election.
That also I am disputing in my preliminary
That is a
counter
different issue.
that I have not issued any such letter.
There should not be any wrong recording of fact. That is the reason why I intervened. My lord, I am extremely sorry. It may be explained for that. Because
the compromise decree is what date?
Compromise decree is subsequent, my lord. Annexure 2 is the government, the opposite number 3 applied to the government for transfer of the land to in my favor.
That also I dispute in my counter, my lord.
Please wait. Let me say, my lord, page 15, Lordsman can leap on 5. Because there should not be wrong recording of fact. That is the reason why I am ruled. Page 15, my lord, Lordsman can listen. My lord, so 26 to 98. 26 to 98.
Who filed the suit and why did he file it?
Well, first of all, just 1 minute, my lord, one fact. Well, 26 to 98, the opposite number 3 applied to the government for transfer of the land, permission of the land, sanction for transfer of the land to in favor of the present petitioner. That government was pleased to accord that sanction, and accordingly we have deposited consent fee. Thereafter, probably some dispute arose. Therefore, the suit was filed subsequently.
My lord,
Please, Mr. Mantha, please let me complete. But the suit was filed on 1598. 1598.
It's all around the same time, sir. I don't know what. Anyway, in the suit, you say.
With all humility, my lord, in preliminary counter, my specific stand is that I have not.
Only to avoid non-recording of.
We have not accepted his submissions or allowed his submissions. Please allow to simply record.
I'm sorry, my lord. I am sorry, my lord. I have all respect for Mr. my senior, my lord, but I also want to bring
only correct statement of fact. That is the reason why I intervened. Otherwise, I would not have. I never interfered in any year. That only reason. Annexure 2
on the basis of a decree, compromise decree dated 2/7/1998 in TS number 214 of 1998.
27/7/1998.
27/7/98. All right, 27/7/98 in TS number 214 of 1998. First of the said suit was filed by the present petitioner when an order dated 26/2/1998 passed by the GAD purportedly permitting such transfer was not implemented. Paragraph stand of opposite party number 3, however, is that the order passed by the GAD itself was obtained through fraud. He even questions, even the compromise decree is today questioned. And on the basis, and that basis, an application was filed in the civil court for recall of the order dated 27 July 1998. Full stop. When the trial court declined that application, CMP number
1580 of 2016.
1580
of 2016, my lord,
was filed in this court, which is stated to be pending. Full stop. Therefore, the very basis on which the application of the present petitioner for transfer of the lease was made has now been put in doubt by the opposite party number 3, presently represented by his legal representatives. Full stop. In that view of the matter, it is directed that the GAD will, notwithstanding the order dated 8 June 2009, revisit the issue of transfer of the ownership of the lease plot number N-6/231, subject to the outcome of CMP number 1508 of 2016.
Deeply obliged.
Full stop.
Obliged.
Deeply obliged. Deeply obliged.
All right. The petition is disposed of.
List item 28.
My lord, instructions.
Petitioner states the petition is infructuous.
List item 29.
And item 29 on behalf of Mr. Mishra, my lord, I may be permitted to place the matter, my lord.
29, what is the petition number, sir?
My lord,
What is your petition number?
petition number, my lord, double PC number 9137 of 2015.
No, that's a wrong list, sir. We are on the weekly list.
Weekly list item number 29.
He is the petitioner.
Item 29. Double PC number 13395 by 2009.
Correct.
Already password, my lord.
All right.
Weekly list item 30.
30. Here it is a caste certificate. It will be single judge immediately, my lord. It is a single judge matter, my lord.
But the interim order was passed by the Honorable Division Bench.
Division, there was no single bench at that time, my lord.
In 2009?
At that time, in that year, there was no single bench in this honorable court, my lord. All the matters were heard by the division benches. Now the segregation
Bench on 15th March.
Weekly list item number 31.
Item 31, no instruction, my lord.
Counsel, the petitioner states yes, no instruction.
Weekly list item number 32.
No instruction, my lord.
All right.
May please, my lord. May please, my lord.
Appearing for Union of India Lordship 32 item.
Weekly list item number 33. May I please?
The petitioner here in this writ petition challenged the order passed by the London Tribunal. And the facts of the case is that the petitioner was the candidate for homeopathic medical officer under PH category. He was not selected on the ground that there are 127 posts. Kindly see advertisement annexure 1 manner. There are 127 posts were advertised for the post of homeopathy medical officer. The petitioner belongs to PH category, my lord. As per the reservation policy, 3% of the total number of vacancies to be filled up from the PH category. Since the 127 posts were advertised, in accordance with 3%, that will be 4 posts should have been filled up, my lord. What they have done, my lord, they have filled up 3 posts, my lord. My sole grievance is that the rule prescribes the 3 posts from the total number of advertisement posts should be filled up under PH category. They have filled up 3 posts. My lord, kindly see the select list I have enclosed. Page 30, my lord. One chin. I got it. Page 30, man.
Yes.
Serial number 1, Chintamani Naik. Serial number 4, Nirajan Nalini Janna. And serial number 6, Prabin Bala Ponda. They have got appointment. Serial number 2 and 3, they didn't produce the required certificate PH category at the time of selection board. For that reason, they could not get appointment. Since my name find place serial number 5, my lord, Mihir Chandra Pani, my lord. My sole grievance is that since 127 posts of medical homeopathy medical officer was advertised in accordance with the government rule, my lord, 3% post
On to para 8, sir.
Ma'am,
Para 8 of the OAT order, running page 54, internal page 5.
ma'am,
Kindly read, sir.
the applicant does not state as to which category, that is unreserved, ST, SC or SCBC he belongs. Out of 3 persons named above, apparently Praveen Bala Ponda is a woman. Annexure 7 reveals that Chintamani Naik secured 167.82 marks. Krishna Chandra Badayatya secured 126.69 marks. Tapaswini Ponda secured 99.82. Niranjan Nalini Jena secured 92.37. Mir Chandra Pani, the applicant, secured 87.56, whereas Praveen Bala Ponda secured 9.56 marks. Obviously, one post is kept for women. The applicant's position is 6 in the merit list, made for both the male and females. So even if 4 candidates from PH category had been appointed, obviously he would have not got it because he doesn't come within the 3 male candidates. As one is meant for female, so the applicant does not have a claim to the post out of PH category. Was not found suitable by the commission in accordance with the merit list. Hence, his first prayer to consider her claim.
What do you say to this? So this is the main point in the case. You have to meet this.
My grievance is that, my lord. My lord, kindly see the rule, my lord. Page 38, my lord. 38, my lord.
Yes.
4, my lord. 1. The following percentage of vacancies out of the total vacancies arising in a year in class 2 special declared gazetted class 3 and class 4 services.
So 3% of 127 is 4 posts.
4 posts, my lord.
So that is what you are arguing for. You saying it should be 4.
4, my lord.
Now, even if it is 4, that's why in para 8 they're pointing out. Even if it is 4, you don't make it. You can have 3 males and 1 female, correct?
3 male, 1 female.
Your mark is less than the 3rd male.
No, kindly see the list, select list. My sole claim, another ground is that the PH category is a horizontal reservation.
So if it is horizontal, it will be 4.
4, my lord.
If it is otherwise, it will be 3. So we accept your case. Whatever the reservation maximum percentage we accept, still 4.
4.
Can't go more than 4.
4.
Of these 4, 1 is woman.
3
male. Your mark is less than the last.
No, my
male.
lord. My mark comes, my lord, serial number 4. Kindly see the mark list, my lord.
You have to compare yourself with the male, sir, not with the female.
No, my lord, in male, my lord. Kindly see. I have shown, my lord, the mark list, my lord. Just now I have. Kindly page 30, my lord.
Yes. Chintamani Naik is the first.
First, he has got appointment, my lord. 2 and 3.
Badatiya is second.
My lord, 2 and 3 did not.
Tapaswini is a female.
Tejaswini, I think is female.
No. What is Praveen Bala?
Praveen Bala, she has got appointment, my lord.
So she or he, you better be clear now.
She, my lord.
In this state, she, he, all that is interchangeably used.
My lord, my sole grievance is there.
1 minute. So the 3 males are who? Chintamani Naik is 1 male. Krishna Chandra Badataya is 1.
My 2 and 3, they didn't get appointment on the ground. They have not produced the required certificate at the time of submission of PH category certificate. My case is that since there were 4 posts, one Chintamani Naik, Niranjana, serial number 1 and serial number for Niraj Nalini Janna and serial number 6.
So
Praveen
the
Bala.
Jena is 92.37.
They have. I don't have any grievance against them.
No, you must have vacancies, sir. If Chintamani Nayak, Krishna Chandra Badatia, Nirjan Alini Jena, there are 3 males, correct? The third male is Jena, 92.37. You're 89.5, you're 87.56.
My case is that there are 4 posts as per the reservation of PH category. Mine I'm fine plus serial number 6, my lord. The 2 persons serial number 2 and 3, they did not join, my lord. They did not produce.
Is there any waitlist concept? We don't even know.
They have
There
taken
may not
that.
be a waitlist concept.
They have. The tribunal has taken that ground, my lord.
What?
They have taken both the candidate did not join due to they do not produce the original or genuine certificate under PH category, my lord. Since that,
Where has the tribunal discussed that?
I have taken that ground in my.
You taking is 1 minute. You just now said tribunal has accepted this ground of yours. Where is it? Where has the tribunal accepted this ground? Where have you argued that 2 people did not join, so I should have got? Where have you argued this?
Only one password, my lord. Only one password, my lord.
Even in your written submission,
My lord.
you don't say 2 people did not join.
They didn't join. They could, since they could not produce the original documents.
No. So if 2 go, you come to the 4th, right? You come to the 4th. That's not good enough. You should come to the 3rd. Because 1 is a woman, sir. So that's a difficulty.
There are the 3 candidates have been selected. From the 3, 2 women were appointed, my lord. One Nalini Ranjan Jana.
I'm not able to understand.
One Nalini Ranjan Jana and Prabhani Bala Ponda. Both the candidates were women, my lord.
Who are women?
Serial number 4 and serial number 6. Page 30, my lord. Only 1 male candidates have got appointed.
No, but your mark is less than both the women candidates, right?
My mark is, my case there, since if the state would have filled up 4 candidates, then my
No, if you include a woman in that 4, then you don't make it.
No, I know, my lord. If the state would have filled up 4 candidates, then my serial.
No, but they have to also provide reservation for women.
They have got, my lord.
There are only 4 vacancies, sir.
4 vacancies.
1 goes for woman. Of the 3, your list, your number is only at the 4th, even if 2 drop out.
My lord, there are 4 posts, my lord. 1 for women, my lord. 3 for male, my lord. But in this, what the 2?
You can't knock out the woman, please. If that woman has got more than you, she will still make it in the general list. The problem is there are 2 women who got more marks than you.
They have more mark than me.
That's right. One comes in through reservation, one comes through the regular non-reservation quota in the PH.
But they have up.
That was your whatever.
My
You take it as you find it, sir. All right. You said the challenge in this present petition is to an order dated 26th February 2010 passed by the Orissa Administrative Tribunal, Cuttack Bench Cuttack bracket OAT in OA number 1251 bracket C of 2004. Paragraph. The Orissa Staff Selection Commission issued an advertisement inviting applications for filling up 127 posts of homeopathic medical officers in the state. Full stop. There were reservations for ST, SC, OBC, bracket SCBC. Full stop. 3% of the posts were reserved for physically handicapped, bracket PH, bracket candidates. Full stop. The petitioner is a PH candidate. Full stop. At the end of the written and viva voce test, 85 candidates of different categories qualified, and a select list was prepared. Admittedly, the petitioner's name did not find mention in the select list. Full stop. He contended that the 3% quota for PH candidates should be computed from the total number of 127 posts and not on the 85 qualified candidates. Accordingly, the petitioner accordingly argued that the number of posts for PH candidates should be 4 and not 3. Full stop. According to him, if it had been 4, he would have made the cut and got appointed. Paragraph. In response to the above contention, the state pointed out that even assuming that the number of seats for PH candidates was increased to 4, the petitioner would still not make the cut since he secured marks less than the last qualified candidate, even in the PH category. Paragraph. As it transpired, there were 3 candidates appointed under the PH category, one of whom was a woman. Full stop. One other woman was appointed in the general category itself. Full stop. Admittedly, even if the number of PH posts was increased to 4, there would still be 2 males and 2 females who secured marks above the marks secured by the petitioner. Full stop. The petitioner pointed out that of the 6 candidates, bracket, he was 6th in the merit list, bracket, 2 could not produce the PH certificate and therefore were dropped. Full stop. That still left 4 in the fray. Full stop. Considering that the petitioner's marks were less than the last appointed in the general category within the PH category, the petitioner would have still not made it had the number of post vacancies been earmarked for PH been increased to 4. Paragraph. Consequently, the court finds no reason to interfere with the impugned order of the OAT. The petition is dismissed.
Weekly list item number 34.
May I please your lordship?
Yes, please.
But here the petitioner is deemed to be university, not notified under section 3 of the UGC Act, challenges the Odisha Professional Educational Fixation of Fees Act. State government has issued notification directing the petitioner's institution is coming under that act. But the noting says the state government has filed counter affidavit. But
No, tell us all that. Forget counter rejoinder. What is the petition about?
Annexure 8, my lord, lordship, kindly see page 44.
You have anyway been collecting this amount from the students?
Yes, my lord, that is as per the regulation of the UGC, my lord.
Correct. No. The interim order says, come to the interim order passed with this court, 12th May 2010.
Yes, my lord.
Kindly read it, sir.
But the interim order is, but in the interim, it is directed that there shall be stay of operation of the order under Annexure 8, subject to the condition that the extra amount collected from the students towards hostel fee shall not be spent by the petitioner for any other purpose till the disposal of the writ petition. Here,
what is so exorbitant about this hostel fee, which you anyway have collected?
How
are you affected?
14,000 has been fixed by the state.
So how are you affected? Anyway, the student was able to afford it. The student has paid it. You have kept it with you, correct?
Here, the private institution has been, they have infrastructure and all the facilities provided. Not like the other institutions managed by the private.
Friend's client claims more. He had
I'm unable to understand why the university is affected.
No, my learned friend, if your lordship permits me, my lords, I am appearing in VC for the opposite fee structure committee. My learned friend's grievance is probably that he has claimed more as a hostel fee and
yes,
government has fixed less. So he's saying that I have a lot of infrastructure and other things. So therefore I should be given the permission to charge as per my proposal. His proposal
So he
was
is
for more.
charged as per his proposal because of the interim order.
Yes.
That proposal has been rejected under Annexure 8.
You have survived, sir, as a university. This revision of tariff has to happen periodically. So this happened in 2010. We are in 2022.
Here, at the time of that notification, the university is running as per the guidelines of UGC. Thereafter, in the year 2010, the regulation came. As per the regulation, all the private institution deemed to be university will fix their fees and all the fees. As per that regulation, the institution is running. That was not before your lordship. I will file the regulation in the year 2010.
What survives in this challenge?
This one
After this, you have been collecting your own fees.
Lordship may disposed of with a direction if cause of action survives, then I will approach by annexing all
that should be.
All right. Counsel for the petitioner seeks leave to withdraw this petition with liberty to revive, to file a fresh petition if any cause of action survives. What happens to the money collected?
That money for the 2 years only. Thereafter, the state government has not fixed, and we have collected as per the regulation.
No, they have not collected. They have collected as per the.
I see. All right. The amount collected by the petitioner can now be utilized by the petitioner. The interim order is vacated. Got it. The petition is disposed of.
List item number 35.
Your Lordship. Am I audible, my lord?
Yes, please.
Your Lordship. My lord, in this
I'm
case.
appearing for it. Go on.
Your Lordship, I am for the petitioner. Your Lordship, in this case, my lord, that the
what is the petition number, madam?
Read petition number, my lord. Your Lordship.
Yes, please. Yes,
11692 by 2010.
All right. Tell us what the matter is.
Your Lordship. That in this case, the petitioner that is running a motor garage, my lord, that land occupied that belonging to ITCO, my lord, since 1999. So ITCO under Annexure 7 and 8, that are minutes of meeting of the year 98, thereafter in 2004, and a partially modification of that the person who are in unauthorized occupation and running certain business, doing certain business, those the meeting minutes of meeting says that they should be regularized on payment of some concession money. And as per that resolution, my lord, I applied before IDCO. But other similarly situated person have already been, my lord, regularized under Annexure 10. I have annexed that document. But petitioner is discriminated. Therefore, my lord, earlier he approached before this honorable court, and this honorable court directed to consider as for that resolution, my lord. But that has been rejected under Annexure 1. Your lordship may kindly see that is the impin order, my lord.
What is the current position? You're still there.
Current position, my lord, as per instruction, my lord, yesterday, my lord, there is an interim order of status quo, my lord, protecting my position. So therefore, my lord, I contacted with my client, but till that there is not any motion made by the IDCO for regulation, my lord. My lord, reason given by the IDCO is there is no land. It is a non-application of mine because I have not approached for any extra land. I am only approached that the land occupied means that has to be regularized.
So basically, whatever you have encroached should be just given to you.
Your lordship, that is a
nice strategy. Wherever you find land, you just go occupy it, and then you say, anyway, you have land, give this to me. Correct?
My lord, that as per the resolution of your lordship, that is, my lord, Article 14 will come into play because
negative equality doesn't come in. You can't say they're all encroaches. So
your lordship, that is right. But your lordship kindly see that Annexure 10, my lord, Annexure 10, all others portion are page 28.
What is the market value of this land you encroached on?
Market value now, my lord, only thing that since 2099 I am in position that status order is there. 1999.
So what is the market value now? What was the market value 1999?
There is a resolution.
Where is this land located, madam?
Land located in Raulkela, lordship, kindly page 4 I have mentioned.
Which is this locality? Busy locality, remote locality?
Commercial estate Raulkela.
Commercial estate Raulkela.
So commercial estate can't have a low value. It has to be high value, correct?
Lordship, but resolution is there. There is 4% of land value per year. They have to be reimbursed for the occupier, my lord.
Madam, today if you were to sell this land to somebody, how much will you get?
Lord,
what is the extent of land? What is the extent of land?
Extent of land is 30 feet into 70 feet. That is a 2100 square feet, my lord.
So if you were to sell this land, what will it fetch in the market today?
My lord, I will not sell because I am running, my lord. I am living.
No, we want to know the value of what you are occupying.
Value, lordship, my lord. That is because others have been regularized on that basis. If a lordship direct, I have to approach the authority, and as per resolution, they will
if you agree to pay the market value, today's market value, you should agree to pay. Only then.
Market value, my lord, I have not obtained instruction. My lord, as per my instruction.
We'll pass it over. You have a mobile phone, no? And your client also has a mobile phone.
Your lordship, may I pray one thing, my lord? May I pray one thing? I have already, in the meanwhile, I have already pursued many times. They have assured me. So, liberty may be given to approach the authorities, my lord.
All right. What happens to your possession then? Anyway, interim order will vacate. You say,
your lordship.
Yeah. Counsel the petitioner seeks leave to withdraw this petition with liberty to approach the authorities in accordance with law. Disposed of is withdrawn with liberty is prayed for. The interim order stands vacated.
Interim order till consideration, my lord?
No.
Because since, my
madam, nobody is going to do anything to you. That's how this country works. Yes.
Weekly list item number 36.
36, I prefer pass over.
All right.
Weekly list item 37. Weekly list item number 37.
None appears. This is not possible.
My lord, appearance of Union of India may kindly be noted.
Or
I am
I am appearing, Your Lordship, Amitabh Pradhan, on behalf of Union of India.
All right.
Weekly list item number 38.
My lord, on behalf of Mr. S.B. Jaina, no instructions. Item
Counsel petitioner states he has no instructions.
Weekly list item 39.
Then appears to not possible.
My lord, item 39. On behalf of Suresh Kumar Chaudhary, I pray for matter will be taken up next week.
Not accepted, sir. You'll have to carry on with the matter. Where is your paper book?
Sir, due to some personal problem, Mr. Chaudhary.
No, we're not adjourning, sir. The adjournment is refused.
Counter also they are not sought to.
Where is your paper book, sir? Sir, can you move this side? Let him talk into the mic. Please come, sir, and speak into the mic. Where is your paper book?
Sorry, man. I have not.
Sorry?
Sorry, man. I have not.
So what do you want us to do? We're not adjourning the case.
The eviction order was passed in 2010, but it appearing no status quo order. So what is the status, whether he has already been evicted, because
Anyway,
it is a detailed
Mr. Counsel,
property?
the petitioner who stands in for Mr. Suresh Chaudhary does not have the paper book. The reason for seeking adjournment is not convincing. The court is therefore not inclined to adjourn the matter. Without a paper book, the counsel is unable to make submissions. The petition is dismissed for non-prosecution.
Weekly list item number 40. Weekly item 40.
None appears, dismissed for non-prosecution.
My lord, appearance of Union of India may kindly be noted.
All right.
Weekly list item number 41.
May please your lordship. I am for the petitioner. In this case, my lord, the petitioner challenges the order dated 3/11/2010 passed by the Lawrence CAT in TA number 13 of 2010, thereby illegally allowing the TA 13 of 2010 consideration by the NALCO wrongly interpreted the employment on compassionate ground, my lord. The case of the petitioner is like that, my lord. The petitioner, along with one Sripati Pan, approached the labor authority in the year 1996, my lord. 41.
Yes.
Petitioner's father, along with 6 others, in the year 1996, approached the labor authority to regularization in their NALCO establishment. They have filed the labor authority awarded on 27/4/1993, challenging that award. The NALCO preferred OJC 4182 of 1993 before this honorable court, and this honorable court offered the award of order dated 5/3/1997, my lord. NALCO, challenging that order, went to Supreme Court in SLP number 12,605 1997 and lost there, my lord. After losing there, he has filed the review petition, my lord. Review petition lost. In that, after lost in the review petition, NALCO gave appointment, issued the offer of appointment as per the award dated, award passed in by the labor authority, and stated that the opposite party should join. By the time the offer of appointment issued to the opposite party number father, by that time he was died, my lord. Except the father of the opposite party number, here, my lord, the present case, all other have joined and work with the NALCO, my lord. In this present case, my lord, after death of the father of the petition opposite party, my lord, the opposite party applied after long gap with the NALCO for compassionate appointment, my lord. The NALCO said that NALCO said that as because there is no compassionate appointment, who had died in harness is in there before the NALCO, hence rejected his petition, my lord. On that, my lord, he has preferred and writ petition before this honorable court, my lord. And after preparing this honorable writ court, by that time the central government, the matter was transferred to the CAT, and CAT the renumbered as TA 13 of 2010, my lord. and the Honorable CAT by order under Annex 13, thereby directed that by Annex 3 as paid 19, my lord. The operative portion of that I am reading, my lord. In the light of the discussion made above, the order of rejection under Annex 5 dated 5/6/2000 is passed. The respondents hereby directed to consider the case of the applicant for providing employment on compassionate ground within a period of 60 days from the date of receipt of the order.
So by now you should have complied with it. There is
In
no
lieu of
stay of
that,
the.
I have complied the order in the sense, my lord. They have prepared another writ petition for claim of their father's legitimate dues, my lord. I have already by annexer
No, no.
5,
Our-
6. Yes,
Sir, against the impugned order here
Yes,
of the CAT, there has been no stay granted by this court. While issuing notice in this petition,
yes, ma'am.
we did not stay the operation of the tribunal's order.
Yes, ma'am.
So you should have complied with the tribunal's order, correct?
Yes, ma'am.
You have complied?
Yes, ma'am.
So what survives?
Complied in the sense, my lord. I have not given him offer of appointment, my lord.
Who asked you to give him appointment?
Yes, ma'am. And that sure I have given.
No. So what survives in the petition then?
And the opposite party has not come before.
Yes.
Yes, ma'am.
You see, there has been no stay of the impugned order of the CAT, which merely asks the petitioner to consider the case of the opposite party for providing employment on compassionate grounds within 60 days from the order and communicate that decision to the opposite party. Full stop. According to counsel of the petitioner, the said order has already been complied with. Full stop. In that view of the matter, nothing survives in the petition. It is disposed of as such.
Obliged.
Waste that time trying to figure out what the facts are.
Weekly list item 42. Weekly list item number 42.
None of this dismissed, not possible.
Under appearance of Union of India may continue.
All right.
Weekly list item number 43.
On behalf of Mr. Wag, pray for after lunch, my lord.
Sorry?
On behalf of Mr. Bag, pray for after lunch.
Not after lunch, sir. We'll only pass it over. We can't tell you after lunch, after this time, or after that time. We're merely passing it over. Right.
Weekly list item number 44.
No cause of action. 2010 matter. Council with petitioner seeks leave to withdraw this petition. Dismiss is withdrawn.
Weekly list item 45.
45 matter, no instructions.
No instructions.
Weekly list item 46.
Item 46, I am for the opposite party. Here the
None appears dismissed and non-possible. Right.
Weekly list item 47.
None appears dismissed and non-possible.
Weekly list item 48.
None appears dismissed and non-possible.
Appearance of Union of India.
All right.
Weekly list item number 49.
Item 49. May I please? In this case, my lord, the petitioner is challenging the impugned order of adverse entries, which has communicated to him in a belated state. But before that, I have filed the death chart, your lordship. Can you? May I place the death chart?
Yes. We've read the day chart, sir.
Yes, ma'am. 5/7/1976.
No, we have just read. We finished reading the date chart.
Yes, ma'am.
So you can make your submission.
The lordship may just have a glance. Annexure 1 and 2.
Yes.
Page 12 and 30.
Yes.
These two are the adverse entries which has communicated to me in 21/1/2012.
Right.
The adverse entries are for the period 18/6/2007 to 26/2008. After 4 years. I relied upon the judgment of this honorable court.
Correct. Delayed communication itself is bad enough. What do you say, Mr. Mudli?
Your lordship, kindly see the prayer. And here there is no prayer for quashing of the adverse entries.
Prayer is quashing of the annexure
1, 2, 5, 6, and 7,
Yes,
sir.
ma'am.
He is quashing. He's asking for quashing.
But
impugned order as at annexure 1, 2, 4, 5, and 6. 1, 2 are the impugned adverse
But the
remarks.
second one is within time, sir. 15, 12,
Second
20,
one,
10.
second one is within time, but the rejection order which was communicated to me without any reason. That is annexure 6, your lordship may see. That is annexure 6, page 30, my lord. May I read it? I am directed to communicate to you that in compliance with the order of this honorable court passed on 27/7/2012 in WPC number so-and-so, the honorable district and session judge Cuttack, on considering your representation so dated 6/2/2012 to ignore the adverse entry in CCR for the period so-and-so, has been pleased to reject the same.
without any reason. And the same, yes, sir. And this judgment
No, no,
also
no, no.
covered
There are
that
two-
also.
No, no.
If the
Let's one
order
minute, sir. There are
suffers
two.
from any reason, it has to be quashed.
So there are two sets of adverse entries, correct?
Yes, ma'am.
One is for the period
One is
18
from
June 2007 to 28 June 2008. That is belated. There is case law. So even if that goes, the next one is 15/12/2010 to 29/8/2011.
yes, ma'am.
That remains.
That also rejected in the next paragraph.
Correct. So that adverse entry remains.
That also rejected. My representation has rejected by the
Correct.
without any reasons. Once you reject my representation or reply, you have to give reasons. That is the judgment what I have already been.
Where is the earlier order? 27th July.
27th July.
Of this court, sir.
Of this court, as page 4 of my writ application, I have
quoted it.
Quoted.
All right.
Page is start from page 4. The relevant portion is page 6, para 8.
No, where is the case law to show the rejection of a representation against adverse ACRs has to be a reasoned one? Where is that case law?
What?
Rejection with regard to the adverse entries must be preceded by reasons or followed by reasons. Whether there is any authority law.
That judgment I have given. It deals with in para para 28. The judgment page 69, para 28. The aforesaid annexure 3 only shows that her representation for exposure of adverse remarks in CCR for the year 2010 and 11 has been rejected and communicated in 2015. No reasons has been assigned for that. As observed in the decision,
The Lords may remand the matter for reconsideration. The Lords may remand the matter to pass a rescind order.
How many times to remand? The man is superannuated now.
Yes.
Financial it is true, my lord. The man has already been retired from 2012 on 31/7.
How many times to remand and how many times to do this? He'll only get some monetary benefit now.
Yes, ma'am.
Because we have not.
No, again his case has to be placed before a DPC without these ACRs. So the highest relief he'll get is his case will be before a DPC without the ACRs. If they give him notional promotion, he won't get actual arrears of pay. He'll only get a refixation of his pension.
Yes, ma'am.
You say there were two sets of adverse entries in the ACRs of the petitioner. One was for the period 18 June 2007 to 20 June 2008, which was communicated to him only on 21st January 2012. The second was for the period 15/12/2010 to 29/8/2011, which again was communicated on 25th January 2012, which is within time. Paragraph. The petitioner's denial of promotion was obviously based on the adverse entries in the ACRs. So when he made a representation against the adverse entries, that representation was rejected by an order dated 10th January 2012 of the Registrar, Civil Courts, Cuttack, by the following order. Reproduce page 30. Paragraph. The reference in the above order to the earlier order of this court, dated 27th July 2012. Was occasioned. You say the order dated 27 July 2012 passed by this court in writ petition civil 11323 of 2012 filed by the same petitioner held that the Departmental Promotion Committee bracket DPC as well as the district judge ought not to have taken into account while considering the case of the petitioner for promotion to the post of
Sirastadar, district court Sirastadar cadre, district court Sirastadar cadre.
District court Sirastadar. Without disposing of his representations against the adverse ACRs, was not lawful, was not justified. Therefore, the matter was sent back to the district judge to consider the petitioner's promotional claim after disposing of his representations. Paragraph. As far as the adverse entries for the period June 2007 to 20th June 2008 is concerned, clearly the communication of such adverse entry was highly belated, having been made only on 21st January 2012. Full stop. The decision of this court in Suchismata Mishra, this is Registrar Administration, 2018, 1 ILR CUT 57, supports the case of the petitioner that the non-communication of adverse, the delayed communication of adverse ACRs would render reliance upon such adverse ACRs unlawful. Paragraph. As regards the second issue, that there should have been reasons given for rejecting the representation against the adverse ACRs for the period 15/12/2010 to 29/8/2011. Again, in the same decision, this court relied on the decision of the Supreme Court in Devdutt versus Union of India, 2008, 8 SEC 725, holding that there have to be reasons given for even the rejection of representation against adverse ACRs. Stop. It is plain from a reading of the impugned order dated 10 September 2012. There are no reasons given by the Registrar Civil Courts Cuttack for rejection of the petitioner's representation against the adverse CCRs for the period 15/12/2010 to 29 June 2011. Paragraph. At this stage, Mr. Mudali, appearing for the opposite parties, submitted that the matter should be remanded to the Registrar Civil Courts for a fresh decision on the petitioner's representation. Paragraph. The opposite part, the petitioner's representation. Full stop. Paragraph. The petitioner has superannuated in
31/7/2012.
On 31st July 2012, almost 10 years ago. So at this stage, to again remand the matter to the Registrar Civil Courts for a fresh decision would only delay matters and prolong the agony of the petitioner. Full stop. Consequently, the court refrains from doing so. Full stop. It is now directed that it is directed as under the impugned decision communicated to the petitioner on 10 September 2012 is hereby set aside. 2, the case of the petitioner for promotion as Sarastidar notionally when his juniors were so promoted will be considered by the DPC. 3, if he's found eligible for such promotion, his pension will be refixed from the date of his retirement, but he will not get any arrears of pay consequent upon such notional promotion. 4, the arrears of pension as calculated in 3 above, will be paid to the petitioner not later than 8 weeks from the date of such decision, which should be communicated to the petitioner not later than 2nd May 2022. The petition is disposed of the above terms.
Weekly list item number 50.
No instruction, madam.
Council petitioner states yes, no instructions.
Passing. Weekly list passed on matter item number 9.
Well, I got instruction. Final say he is going to retire on 31st March 2022. Man.
22. So we just leave the question of law open, sir.
Yes.
Considering the fact that the opposite party is going to retire on 31st March 2022, the court considers it appropriate to direct that the question of law arising from the impugned award of the Industrial Tribunal Bhubaneswar in industrial dispute case number 3 of 2003 is not interfered with, subject to the observation that it would not constitute a precedent and will be understood as being peculiar to the facts of the case. The petition is disposed of. The petition is disposed of. We have said it won't constitute a precedent. Minutes. We have said that the award will not constitute a precedent.
Only areas, minutes, areas should only areas should be given.
Areas should be?
No, minors directed that it will not be standing as a precedent. So only this much, minors.
That's all. Whatever you have to do, you do, sir. The award has to be implemented, you implement it. Yes.
Weekly list passed on matter item number 29. Item number 29. WPC 13395 of 2009.
Is there in the first call? You asked for a passover. A passover is sought when the matter was first called out. After passover, none appears. Dismiss for non-prosecution.
Weekly list passed on matter item number 36.
May I please? Matter relates to retrenchment of the workmen at the state manual before the land tribunal, industrial tribunal. We raised the plea of protection under clause BP of section 200 of the industrial disputes, and that has been negated by the land tribunal. So may I draw your attention kind to paragraph page 10, paragraph 3. It's part of the award. What is the stand of the management before the land tribunal?
Yes.
The management, that's at bottom, page 10 bottom, the management entered contest and filed its written statement. While in one hand, it has admitted about the engagement of the workman from 2000 till 2007, up to 30/11/2007. But on the other hand, it has stated that the building center in which the workman was engaged was established under the self-financing scheme. And on closure of such scheme, the staffs employed in the center, including the workmen, were disengaged as per decision of the 5th board meeting of the management. It is the specific stand of the management that the scheme under which the workman was engaged, being no more in existence, the workman is not at all entitled to any relief in the present reference. And accordingly, it has tried to answer the reference in the negative as against the workman.
1 minute. Who's appearing for the opposite side? So Sanjay Mishra was appearing at one stage.
Then my lord, we can do paragraph 6.
No one appearing on the other side. What is the relief granted?
Reinstatement, but so far as back wages is concerned, that's a lump sum amount 10,000 only. Page 16, paragraph 11. In view of the discussions made in the preceding paragraph, the workman is held entitled to reinstatement in service forthwith and as regards back wages, the management is directed to pay him a lump sum amount of 10,000.
What is this man's age?
The age I could not find in the award. That is not their age is not there. So also in the cost title, the age is also not there.
So does it stay?
Yes, madam. Subject to compliance of 17B.
17B paid. I mean, that doesn't seem to be the case. You got to stay in 2010.
Yes, 23/8/2010.
Can you find out what the age of this man is? Because
Yeah,
if he's superannuated and there's a stay, he'll only get some 10,000 rupees.
Because I could not get his age, particular
There will be
age.
no reinstatement. Find out his age, we'll pass it to.
Weekly list, passed over matter item number 43.
Please, your lordship, my lord. I am for the petitioner, my lord. I am for the petitioner, my lord. My lord, in the meantime, since
The Sadashiva Pradhan, sorry, Mr. Mudali, the Sadashiva Pradhan is the opposite party, right?
Yes.
So he was 42 years in 2010. So now he's 54. So he's not.
He's in service.
What was his designation? What was he working as?
Yes. Watchman. Watchman.
See, Mr. Sanjay Mishra, advocate,
fact,
has
I was
filed
very-
wakalat now on behalf of the opposite party, but today it does not appear.
No, I was verifying the order dated 6/10/2020, and Mr. B.K. Mahanti was appearing for the opposite part number 1. Order dated 6/10/2020.
B.K. Mahanti.
Yes.
On 6/10/2020, Mr. B.K. Mahanti appeared for opposite party number 1. Today, however, none appears for the opposite party number 1. The registry will inform Mr. B.K. Mahanti, advocate, to remain present on the next day. List on 25th April.
Passed over item number 43.
May I please, your lordship? My lord,
Yes.
in this case, I am appearing for the petitioner, my lord.
Yes.
Here, the main objection is against opposite party number 4, my lord. In whose favor government land has been directed to be settled. My lord, this opposite party number 4 is dead. So I filed, your lordship, may kindly see flag D. I filed substitution petition. Notice we are issued to the.
We allow that. We allow that. Substitution application allowed. So this impugned order by which he has been allotted land, Annexure 4, it's by the additional Tahsildar.
My lord, my submission is, it was.
No, you answer the question, sir. Is it by the additional Tahsildar?
My lord.
Is it an
Annexure
appeal?
4, that was the application of the opposite party number, claim of the opposite party number 4 was rejected.
All right.
Then he filed appeal.
Filed
Annexure 6, even though the appeal was not maintainable because it was under the executive circular of the government, section 9 application to the Orissa State Abolition Act is not applicable at all. That is held by this honorable court by division bench. Now, but they filed the appeal, ignoring the law that after vesting, the intermediate interest vests in government, free from all encumbrances, in view of section 3A of the Orissa State Abolition Act, my lord. But here, after vesting is of the year 1953-54, my lord. In 62 by registered salary, the intermediaries have transferred the land in question, which is a public tank, in favor of the opposite part number 4. So in the Hal ROR, his name was recorded with Bebandobast status. That means rent was not fixed. Tahsildar initiated a sumoto proceeding by Annexure 4, my lord. And after taking into consideration all the matters that the sale is of 1962, he refused to declare him as a Sthitivan tenant, occupancy tenant, and directed it to be recorded as government land in Rakit Kata, reserved land, my lord.
Sir, who was appearing for the opposite party number 4?
Alas, I am appearing, my lord. I am in impeachment. For legal matters of opinion 4, I am filing power.
Okay.
And my father has also filed a counter. I adopt this amendment.
Okay.
My lord, this honorable court, exactly on the similar matter, reported in 2007, volume 1, OLR 89, has categorically settled the law that a case decided regarding a Bebandobast case under executive circular, no appeal lies under section 9 of the Orissa State Abolition Act. But here, the sub-collector has exercised the appellate power under section 9, for which he has no jurisdiction at all. Your lordship may kindly for a moment see the Orissa State Abolition Act, section 9, my lord.
All right. 1 minute, sir.
Section 9, my lord.
Yes.
Appeal against collector's order under section 3, 3B, 5, 6, 7, 8, and 8A. 1. An appeal against any order of the collector under subsection 4 of section 3B, clause H and I, and K of section 5, subsection 1 of section 8 or 7, subsection 2 and 3 of section 8, section 8 and subsection 3 and 4 of section 8A, if preferred within 60 days from such order, shall lie to the Board of Revenue, which shall dispose of the appeal according to the prescribed procedure, provided that if such order is passed by an officer other than the collector of the district, an appeal is, if preferred within 60 days of such order, shall lie to the Board of Revenue, and which shall be disposed of the appeal according to the procedure, according to the prescribed procedure, provided further that if such order is passed by officer other than the collector of the district, an appeal, if preferred within 60 days of such order, shall lie to the said collector, who shall dispose of the appeal according to the same procedure as is preferred to the disposal of such appeals by the Board of Revenue. My lord, here the order under Annexure 4 was passed by the Tahsildar under executive circular. Your lordship may kindly see exhibit Annexure 4, my lord, for a moment. Annexure 4.
Yes.
Page 18, my lord.
Yes.
My lord, the fact of this case is that the
Just
suitland
make your point, sir. Why are you
My
reading
lord.
this?
Page 18 annexure
Kindly
4, my
make your
lord.
point. Why are you reading this?
My lord, because the case was initiated under the executive circular, so moto by the Tahsildar, not under any of the provisions of the Orissa State Evolution Act.
All right.
If I can show your lordship that Tahsildar exercised its jurisdiction under the executive circular, but not under any provisions of the Orissa State Evolution Act, then no appeal will lie to the appellate authority. Here the sub-collector, my lord. Because the order, this annexure 4 was challenged by the opposite party number 4 in appeal. And the appellate order is annexure 6, my lord. There the collector, appellate authority, directed to record the name of opposite party number 4 on Sthitivan status, and thereafter by annexure 7, Tahsildar has corrected that. So, my lord, that is a communal land, and your lordship will find from section 5I of the Orissa State Evolution Act.
So how are you affected?
My lord, we are the villagers. We are using that tank. That is a pond tank since time immemorial. And
all right. So let's hear Mr. Mohanty. Okay, let's hear Mr. Mohanty.
No, admittedly, appeal is not maintainable.
Then the order has to go, sir. If the appeal is not maintainable.
But only the OP number, legal as OP number 4 may be permitted to challenge annexure 4 under the circular dated 6/12/2020 before member board of review. That observation is given.
All right. The challenge in the present petition is to an order dated 20th April 2000 passed by the Tahsildar Sadar Baleshwar in SRF case number 153 of 1987, as well as the order dated 19 July 2020 passed by the Sub-Collector Baleshwar.
2010, my lord, not 20.
Yeah, by the Sub-Collector Baleshwar in RF appeal number 23 of 2000, as well as the consequential order dated 18/12/2010 passed by the Tahsildar Baleshwar in the same SRF case number 153 of 1987, carrying out the mutation in the record of rights bracket ROR pertaining to the suit land in favor of opposite party number 4, is it? 4. Paragraph. One of the first submissions made by Mr. Manesh Bagh, learned counsel appearing for the petitioner.
No, my lord, I am Bansidhar Bagh, my lord, not Manas Ranjan Bagh.
Okay. Mr. Bansidhar Bagh, learned counsel appearing for the petitioner, is that the orders of both the Tahsildar Baleshwar as well as the appellate order of the Sub-Collector Baleshwar were entirely without jurisdiction. Apart from the fact that no appeal was maintainable under Section 9 of the Estate Abolition Act, Orissa Estate Abolition Act, against such an order of the Tahsildar, he pointed out that Tahsildar himself could not have exercised suo motu powers under the OEA Act. Paragraph 11, counsel for the opposite parties does not contest the legal position that no appeal was maintainable against the order of the Tahsildar, or even that the Tahsildar could not have suo motu. Tahsildar, full stop. The said appeal was filed by the opposite party number 4. Full stop. In view of the above statement, the impugned order dated 19 July 2010 of the Sub-Collector Baleshwar in RFA number 23 of 2000 is hereby set aside. Paragraph. Liberty is granted to opposite party number 4.
Legal heirs of opinion 4.
Legal heirs of opposite party number 4 to question the order dated 20th April 2000 of the Tahsildar Sadar Baleshwar.
Before the member board.
SRF case number 153 of 1987 in appropriate proceedings before the Board of Revenue in accordance with law. As a result of the above directions, the order dated the consequential order dated 18/11/2010 of the Tahsildar Baleshwar is hereby set aside. The petition is disposed of in the above place.
Supplementary list. Press admission item number 1.
Here, Lord, the revenue has challenged the appellate authority order and framing the question that whether the fact and circumstances of the case, the tribunal is correct to invalidate the proceeding on the ground in the notice he has received is beyond the period of 15 days of period has not been mentioned. In this background, my submission would be 158 BC is a procedure for assessment. It is not as good as the proceeding of the 148 of the income tax, as strict compliance will be made. And fact remain in this case, before I go to the tribunal background of the fact is that the notice for the 158 BC assessment dated 5/1/2020 to file return on 2/2/2020. That is 28 days. But he received the notice by the assessee on 21/2020. And he has not filed, not asked for an extension, though it was specifically mentioned that the notice has to be, the assessee has to file return beyond 15 days before 45 days. That is the contents of the procedure for assessment. He has filed the return after completion of assessment. That is on 15/5/2001. And nowhere in the assessment proceeding, he has questioned that notice. Therefore, my humble submission is that as being this section is a procedural in nature, then it cannot be said that the notice is invalid and the procedure assessment is not good.
All right, 1 minute. Should we continue after lunch? This is part of this. We'll continue after lunch. This part of this. All right.
My pardon, my lord. On item 29, before launch, my Passover prayer is allowed by my lord. But court master says your case disposed before launch.
Correct. It was called out of Passover.
Generally, Passover matter taken after launch.
No, not in this court, sir. Passover matter will be taken up after the list is over.
My Passover.
We called out the weekly list. Weekly list Passovers we call out at the end of the weekly list.
But at least tomorrow we take.
Or if you want to argue now, you do it.
Yes, I am ready.
Argue.
Mobile erection is silent.
In this case, the prayer of the petitioner, my lord, to pass the improved order by the annexure 5 passed by the member board of revenue Cuttack and upholding the annexure 1 passed by the revenue authority by the annexure the order dated 2/11/83. The learned collector Jaspur initiated proceeding against the petitioner after 26 years 6 months. On the ground, the member board of revenue set aside my settlement on the ground. The father of the petitioner committed a fraud. But during hearing, father already expired, my lord. The learned member substitute petitioner as a substitute petitioner. In this case, my lord, the annexure 1 had rightly passed. No irregularities maintained by the revenue officer in by order dated 12/11/83 by the annexure 1. The member board of revenue in this last order set aside the annexure 1 and directed to Tahsildar Sukinda to evict me without any opportunity. That is also illegal and unconstitutional also, my lord. In my prayer, my lord, kindly see the order of honorable member of board of finding of the irregularity running page 17. There is the order dated 30/12/83 of OEA collector come Tahsildar Sukinda in OEM case number 404/1983. It is a carbon copy of a impression in which a few blanks have been filled up in ink with a detail specific to Navahana Deo, who is my father, my lord. That is also 35 or 40 years back. That is also all are used in fountain pen, my lord. That time not introduced. But about finding fraud, decide member board of revenue is a revenue authority, absolutely has no authority to decide fraud. If question of a fraud arise, matter is referred to civil court only. So my respectful submission, annexure 5 is an illegal arbitrary order, it will be passed, and annexure 1 is a good order, and it was confirmed.
So these orders we've upheld, similar orders we've upheld
Yes,
yesterday.
similar orders your lordship has already upheld in many cases of the same Tahsil.
Correct.
Sukinda Tahsil.
Correct.
And that's same story, Hatpata, no rent receipt, no tenant ledger, no ekpadia, nothing.
No, my lord has
and the Tahsildar has settled the, and
no,
the lordship has already.
No, my lord has a passed earlier order. The honorable member has a no jurisdiction. That order also passed by this honorable court.
No. Sukinda, we've upheld all the orders, sir.
But that order not in irregularities.
Right.
If case land was recorded in the name of the petitioner,
right,
then fraud can be committed.
Right.
Case land was recorded in the name of my father of the petitioner.
Right.
And if the finding of the member accepted, till that the petitioner as well as the predecessor interest enjoying the case land more than 70 years.
Right.
After the 70 years, member board of revenue directed to revenue officer Sukinda to evicted me. It is a natural justice. Petitioner is a farmer.
Right.
The revenue officer settled the case land as a agriculture purpose.
This is Anabadi land, sir.
Yes.
Yes, my lord.
That
Anabadi, not Anabadi, my lord.
Yes,
Section
yes.
40.
Yes.
This is Anabadi.
No. In 1928 settlement, that the land was recorded in the name of the ex-proprietor, my lord.
Sir, page 18, right now it is Anabadi. That's the status. All right.
1928, my lord, that is a civic settlement, my
All
lord.
right. We simply say the petition is dismissed, the detailed order will be passed. Right.
Well, file a decision within 2 days, 3 days.
Sorry?
Decision.
No, we have enough, sir. When you discuss
The Honorable Justice S. Naidu has already decided in 38B, member of Board of Education has no jurisdiction to interfere in this.
All right. Right. Yeah, you can take up at 2 p.m. 31. Yeah.
Item number 31. Supplementary list, item number 31.
My Lord, may kindly see the order dated 30/11/2021, order number 26. In paragraph 15.
Speaking of 31, item 31, my lord, that PIL is it? One?
Correct.
I have item 3, my lord. May I be permitted to do it next week?
Who's for the other
Because
side,
by
sir?
this matter, just engaged.
No, who's for the Mr. Mudali?
Yes. Mr. Malik was doing, I have been instructed today.
No, on the other side.
I am the state.
Acha, it is already listed. You say the request of Mr. Yashobandhu Das, Senior Advocate. We'll have it in April, sir.
Any date might be.
12th April. Right.
Supplementary list, item 31.
May I please?
Yes.
Your Lordship, may kindly see order number 26 dated 30/11/2021. And in paragraph 15, due to communication gap, my lords have observed that a direction was issued to the Secretary Health and Family Welfare Department by order of this court dated 14 July 2021 and 2nd September 2021. No affidavit has been filed by the Health Department. In fact, my lord, an affidavit has been filed on 30/9/2021 by the Director Health Orissa, Director Health Services. It is already on record, and pursuant to this order also, I have filed 2 compliances affidavit by the Additional Chief Secretary Health Department, and pursuant to this order, the Additional Chief Secretary Health Department as well as all the 3 collectors are present.
Yes. What happened in that visit by the that technical committee? Have they visited all the leper homes?
There was a direction that only Mr. Mudali can say whether they have visited those homes.
Well, I have the last instruction which I have received that shows that in the district all the subcommittees have been constituted. Whether they have visited or not, since the collectors of Puri and Khurda and Baleswar are there, they can apply.
So detailed directions have been issued.
Yes.
In the order dated 30th November.
Yes, my lord.
When was your affidavit filed, sir?
Hello. Collector Puri's affidavit was filed.
No, by the technical committee. See, we are now on the technical committee, the level of the state government.
Technical committee's affidavit was filed prior to that, 25/11.
No. 30th November, there are detailed directions.
No, pursuant to our affidavit, this observation has been made at paragraph 14.
No, sir, just come to para 16 of the order dated 30th November.
Para 16.
1/6 of the order dated 30th November, 30 November 2021.
Yes, my lord.
Para 16, sir.
Yes. Para 16 shows that the collector Khurda, Puri and Baleswar should remain present.
No. I think we're reading different orders. 30th November.
Yes, 30th November 2021, and it's of 7 pages.
That's right. Para 16, 1/6.
No, para 16, my downloading copy shows the collector Khurda, Puri and
No.
Baleswar.
Just show him
In
the
fact,
file.
what my learned friend says, we also are holding that same. Order number 26, dated 30/11/2021. Paragraph 16 is collector. What he's saying is that's the one.
I don't know. The scan copy here, see, reading differently.
My lord, once I can share my physical copy.
Okay, I think this is para 19 in our file.
No.
That collectors remain.
The order
I've
which
said
we
here
have
the
done-
court would want to ascertain the views of the state government in adopting best practices.
The order which we have downloaded, that consists of only 17 paragraphs.
How is it possible?
My lords, may I just forward my hard copy so that it can be.
No, the better thing is for you to see our copy. Just give him the copy. There's a subpara saying technical committee from para 15 onwards, correct?
There is some mismatch, my lords. My lords, let's get on with the issue.
No, but you see what directions have issued in para 16. And 17.
Let's probably they have new.
Your Lordships, I mean, we remember clearly that kind of order was there. So it's maybe there's been some mismatch in
I
the
think
downloading.
there's a mismatch in the uploading because the one which we have, it's there. I think our order doesn't have those headings, which is there.
But that we all remember that order and that portion being passed. But there is no affidavit after that on those lines.
Is that even possible?
Yeah, even in the one now we are checking up, this is the one. So there is some issue in the.
No, but we remember that being passed.
Is correct. So how did it happen? Kind of. Mr. Mudali, what we've done is we asked the Additional Chief Secretary Health to file an affidavit indicating the status of compliance with the directions issued by the court.
Yes, we have filed that affidavit.
Additional Chief Secretary filed it when? And we asked him to remain personally present.
Yes, he is present.
All right.
That affidavit we have filed on 27/12/2021. It was filed on 28/12.
28/12. All right.
That is at flag 20.
So we just want to bring it to the notice of the Additional Chief Secretary as well as the collectors. There are 3 policies which actually would change the scenario for all these 87 colonies.
Yes.
Now, those policies
We made a spiral bound, Your Lordships.
we are giving it today.
All right.
There are 3 important policies of this very same government where they have come up with a number of schemes.
In fact, the first one is directly relating to leprosy cured persons. The first one, and that is also in pursuance with the Pankaj Sinha judgment.
Right.
The objective point 2 and 3 is specifically which we want to highlight: promote voluntary action and participation of stakeholders for ensuring effective implementation of scheme, rehabilitation of the cured leprosy patient, and create facilities for providing appropriate rehabilitation services. And in this fourth is promote individual and group initiative by cured leprosy patients for employment, self-employment, and other socio-educational services. Out of the program components, I think 5, 6, 7, 8, and 9 has never seen any of these colonies that we have visited, at least. And if the court looks at even point 9 and 10, that's page number 6 and 7.
This also has not happened.
This has not happened. At least the colonies we have visited has never seen. And I think the important role has been given to the district administration at page 10.
No, first I needed a map of where all these homes are.
I think that's
district wise.
The affidavit.
How many such homes exist? Then we can ask those district collectors to get back to us.
Correct, my lords. My lords, that would be affidavit of the Additional Chief Secretary to Government, Health and Family, dated 3/1/2022. That's sworn to Sri Rajkumar Sharma.
Where is that? Rajkumar Sharma. Additional affidavit of the Additional Chief Secretary. Yes. Which paragraph?
Yes, my lord. If my lord takes up that affidavit, running page 20, annexure H, where all the colonies are there.
Right. So there are
Total
56.
in all, they
No,
are
no,
saying
no.
89.
89, correct.
Now, in this, what three of us have done, my lords, we have identified some of the colonies having a larger population. And that also we have mentioned in our report at flag 23.
1 minute. This follow-up visit? No.
Yes, it's a follow-up visit, flag 23 for Baleswar. In that, at serial number 7, page 3, my lords.
Identification of further colonies.
Yes. Here we have given the serial numbers of those colonies. If they are kept
19.
side by side, these can be added. And we have suggested that the DLSs, if they can give a feedback.
Yeah, 1 minute.
So that feedback can be in terms of the three guidelines which we have given today.
So Mr. Sharma is here, I think, on the VC.
Namaskar. Implementation of these guidelines should be good enough.
Please, sir.
No, you can kindly take your seat, sir. You do not have to stand up.
Thank you, sir.
So what is your response to the suggestion made by the amicus curiae that your own resolution dated 23rd February should be implemented, and you pick up the colonies they have mentioned over a fair range of districts. You pick up these colonies for ensuring that these guidelines are followed.
Sir, we fully agree with the suggestions that we need to develop these colonies further.
Right.
Now here, I will sit along with our concerned secretary concerned, that is the Commissioner of Secretary of SS and EPD department.
Right.
And so work together an action plan, how to go about it. If any change in the institutional mechanism is needed, we'll work that out, sir. If we are given time of about 2 or 3 months, we can have a comprehensive plan for the colony.
Can we also suggest this? You have this technical committee which has formed subcommittees.
Yes, sir.
Can they undertake immediately visit to these colonies? They can spread out among themselves who wants to go where, but let them undertake a visit to know the current situation in these colonies. Then they have a follow-up visit closer to the next hearing so that they can make sure that the steps that you have suggested in your resolution of February 2021 have actually been implemented in those colonies.
Sir, I will have to discuss with the Secretary SS and EPD department who is right now traveling to Delhi. And so technical committee is headed by the SS and EPD department. So we will work out together for the directions which have been given by.
Yeah. So today we will direct that the subcommittee or whichever other personnel that the technical committee authorizes.
Yes, sir.
Will have to undertake at least 2 visits. One immediately in the next 10 days to these colonies, and the next will be closer to the next date of hearing, which will tell us that the resolution dated 23rd February has been implemented in these colonies.
Sir, I agree, sir. We will do that in case, sir, we need to form more teams considering the total number of colonies stated is about 89. If more teams
not all 89. What the amicus curiae have done is
sir, that should be
9, and we'll add the other colonies in Puri and
3.
Khurda.
So 3 existing and additional 9.
So 12. We're talking of 12 colonies, sir.
Sir, that should be eminently possible, and sir, I will work along with the SS and EPD department to ensure that the subcommittee of technical committee makes a visit to all these colonies.
Yes.
So before next date of hearing, maybe somewhere in a period of 1 month. Sir.
Correct. Sir, we had also asked in that order of 30th November, there is some mismatch, but we had asked in a particular paragraph the stand of the government on adopting the Maharashtra model.
So we need to study that, sir. I will need, sir.
All right. We'll make sure you get a correct copy of the order. You also don't have that order, is it? 30th November with that.
No, I have the old.
Older version. I
paragraph
don't know how it
17.
has happened, actually. I'm still trying to figure out. How is that possible?
Sir, we will study the Maharashtra model in more details because the preliminary information we had taken was not adequate. So, if required, sir, now that COVID is reducing, we may even send a team to study the model and implement in right earnest if so that helps our colonies. Sir.
You'll also may kindly see the affidavit filed by the SSCPD department for in compliance of order dated 3/11, that is 25/11/2021, filed by Ms. Madhumita Naik. You'll also kindly take up that affidavit. Now, there we have stated that in the proceeding itself, the technical committee constituted with the Maharashtra
the Baba Amte Foundation, one representative was there. One representative was there from the Baba Amte Foundation in that second technical committee meeting, my lord.
And there also they have assigned the responsibilities to the subcommittee also. That is also there.
Right. You see, the court has perused the affidavit dated 3rd January 2022 of the Additional Chief Secretary, Health, who is also present in virtual mode today. So, the note of the amicus curiae on their follow-up visit to the Louis leprosy colony in Balashore has also been perused. Stop. The amicus curiae placed before the court. Okay, right in the beginning you say there appears to be some mistake in the uploading of the order passed to this court on 30th November 2021. The order that is uploaded now and available on the web does not somehow contain 3 paragraphs. Stop. The order therefore be taken down and be substituted by a correct copy of the order which is already available on file. This direction be complied immediately. And then you say what I've started dictating. You say the amicus curiae have also placed before the court copy of a resolution dated 23rd February 2021, published in the Orissa Gazette of 2nd March 2021, issued by the Department of Social Security and Empowerment of Persons with Disabilities, Government of Orissa, which concerns, which is titled single quotes, an umbrella scheme for rehabilitation of cured leprosy persons, unquote. It contains many objectives and lists out the program components. In some detail. Full stop. The submission of the amicus curiae is that this resolution has not been implemented in any of the colonies they've visited so far. That is the Sanjay colony and what is the
Bapuji colony?
Bapuji colony, the Sanjay colony,
Dharabati colony at Jatni.
Sorry?
Dharabati and Bapuji colony, both the colonies are in Jatni.
Bapuji colony and Dharavati.
Yes, my lord.
Colony in Jatni. Where is the Sanjay colony?
Puri, that is.
The Sanjay colony in Puri and the Louis colony in Baripada.
Yes, that is Baripada.
But we
the colonies, my lords, would find in paragraph 1 of that order, 30/11/2021. All the 3 colonies are there. 2 colonies of Jatni, namely, they have been mentioned in the first paragraph.
Okay. In addition, the amicus curiae have suggested that in the list of 89 colonies given at Annexure H, which was the page?
That's at page 20, Annexure H, affidavit filed by the Additional Chief Secretary.
Sorry?
Page 20, Annexure H, affidavit dated 3/1/2022 by the Additional Chief Secretary to Government, Health and Family.
Right. Refer to the list of leprosy colonies in Orissa, which is at Annexure H. The affidavit dated 3rd January 2022. Of these, they have suggested that the colonies at serial number 19, bracket, Jamunda Leprosy Colony, Bargaon, Katapalli, Bargarh district, in Gandhipalli Colony, PO Naya Bazar, Cuttack, the Nehru Palli Colony at PO Naya Bazar, Cuttack, the Gandhinagar Colony, JK Road, Jajpur, Indra Ashram, Kulemura, Behraman, Jharsuguda district, the Saraswati Colony at Baripada in Mayurbhanj district, the Durgapur B Colony, Malgodam, Rourkela, the Ramakrishna Palli Colony at Harwell Nagar, Unit 3, Bhubaneswar, and the Jagannath Leprosy Colony at Mancheshwar in Bhubaneswar should be taken up in the first phase for implementation of the aforementioned resolution in letter and spirit. This suggestion is acceptable to the Additional Chief Secretary who participated in the virtual hearings. Full stop. It is accordingly directed that the technical committee will instruct its subcommittees or any other personnel authorized by it to immediately undertake, in the next 10 days, visits to the aforementioned colonies, aforementioned 9 colonies, in addition to the 3 colonies mentioned in the para 1 of the order dated 30th November 2021, and prepare reports of the present condition of those colonies. Full stop. 2. The resolution dated 23rd February 2021 will be implemented in the aforementioned 12 colonies in the next three months. A follow-up visit will be undertaken by the committees in the week beginning 16th May 2022 to ascertain the status of implementation of the resolution in the aforementioned colonies, and a further report will be prepared for consideration by the larger technical committee at least 1 week prior to the next date of hearing of this case. What else?
We just wanted to didn't want to trouble your lordship. Page 23 of that compilation, that spiral bound compilation. This is a Bhimo Bhoi Bhinyakshama Samartha Abhiyan. That means Bhimo Bhoi Malaj is a poet from Western Orissa Malaj. He used to work for the downtrodden.
His
and it is for
famous,
differently.
It is on the UNO hall. So.
Okay. So it is a policy for the differently abled. That's what Bhinnakshama means, differently abled. So this also they should keep in mind. This has, in fact, the first policy itself has this. And in addition to that, if my lord would see page.
You say, while implementing the above resolution, the guidelines on the Bhima Bhoi Bhinakshama Samarthya Abhiyan, bracket BBSA, as revised on 1st April 2018. This is issued by the government.
Yes.
Issued by the
in fact, the disability act.
Issued by the government. Then there's one more guideline, Sahaya.
Yes. That's at page 70.
Right. And the guidelines on single quote Sahaya, issued by the same Department of Social Security and Empowerment of Persons with Disability, Government of Orissa, should be kept in view.
In fact, the people, while interacting with them, they are all willing to work. So if my lords would see page 79 of that compilation.
So whatever they produce should be
Yes,
marketed.
so they can be self-sufficient.
Right.
If my lords takes up page 79,
correct.
The government here has listed almost 28 jobs.
Correct.
So if they can take this up on a priority basis,
right,
then automatically things may improve for them.
Right, right. I'm sure the Chief Secretary is hearing you. So there should be no
And
problem.
in fact, the entire tribal department has seen how the SHG's group work very well. I don't know if the court has seen in the airport itself, we have the products there. They are quite affordable in the regular market, not the airport. And they are all done by these SHG groups, and they are also identified to help them to make those produce, and which will have very good, acceptance in the market.
Right, right. What about
The basic facilities have improved in the three colonies. So we are trying to take it to the next level with this.
This one thing about the Puri I wanted to point out, that report is at flag 22. I would want to. In fact, my recent information is that they made the toilets, but at page 5, the court may see page 5 of that report.
All right.
There are photographs at page 5 and 6. These are vacant lands. I've given the detail of the ROR.
Right.
And the ROR also has been provided. This is a land near the other leprosy colony in Puri, which is a name of the, for the purpose of development of leprosy colonies. So the people who are there in this railway area, they have this demanded, why don't you shift us, give us house, and we have proper living there? Because the other colony, which is there near this temple, it was established by the father, and it's quite organized. So they also expect the same kind of treatment. So if they can, the collector Puri is here, very well can
the
look
land
into
is
that.
in the name of the HKNS, Hind Kushtu Nivarana Sangha.
That ROR is there.
Yes, that is in their name.
Yes.
Yes, the collector Puri can come in on this.
Sir, just a query, sir. Is it the same land which is in front of the Loknath temple? Sir?
Yes. That is the same land. Same land.
So the physical status of the land is that we have an urban PHC already constructed on that land, sir. And also the vacant space that remains, sir, is used for large gatherings in front of the temple, which happen multiple times in a year.
I'm sorry, sir. There is absolutely no construction over there. We had visited that place. That is in the name of the HKNS, Hind Kushtu Nivarana Sangha.
I've given the photographs, is very well
That is vacant, sir. That plot of land is vacant, sir.
So I'll do a fact check again, sir. So if it is the case, sir, we will.
Yes. All right. A report has been submitted on the current status of the Sanjay Ji leprosy colony in Puri, as well as the Jivaram Ji leprosy colony in Puri. So, one of the issues raised is that presently the Sanjay Ji leprosy colony is over railway property, and the inmates there have been asking to be shifted to an area of vacant land available near the Jivaramji leprosy colony of Puri, bracket near the Loknath temple. It is stated that the ROR at present is in the favor in the name of the Hind Kushtu
Nivarana Sangha, HKNS.
Bracket HKNS. The collector Puri, who participated in today's hearing in virtual mode, has agreed to do a fact check of the current position and see if the inmates of the Sanjay Ji leprosy colony can be rehabilitated in a facility to be constructed on the vacant land. An affidavit be filed by the collector Puri on this aspect by the next date. Should we have it on the opening day then? June 20th, or you want it in the last week of May?
We want a shorter date. Maybe
sometime 3 months time for implementing. If there's any other issue that comes up, you can always file an application.
What we would request is my lord can have, say, in the last week of April, at least.
No, May. Actually, that will have to be May then.
In between, if anything comes, my lord will
so in the week beginning 9th, you say they have to undertake the visits in the week beginning 9th May. So we'll list this on 18th May. 18th May at 2 p.m.
I'm not really to be noted in the order. This is a recent judgment of Justice Chandrachud where he's discussing the act, the Disability Act,
Right.
where he's talking about the reasonable accommodation and giving it the other side of Article 14. So we dialogue with these people and not to have a general rule for everybody, but meeting the
Tailor
specific
it for the specific.
Yes, to so that can, and which is very important because every leprosy patient will have
You
its.
see, the committees will, during the visits, have interactions with the inmates of those colonies to ascertain what kinds of rehabilitative measures would be best suited for them. All right. All right.
In fact, closer to the date, a lot of activity happens.
That's very typical. That's okay. Thank you. Thank you, sir. Thank you.
We are all very great.
Thank you. We'll also take up that Dinkia matter first, because that will take some time. We'll take up the Dinkia matter now.
Item 39.
Does that will again take some time, or
No, today we are submitting the reports.
only today?
Yes.
Because there's an additional matter that's come up. Yes, please come. Mr. Devdas, you can also step up, and I don't know if Mr. Dalai is here. Not yet.
But his associate is here asking to come.
Then can you kindly wait till the other lawyers in the matters come? All right. You can call out.
Supplementary list item number 1.
Yes.
The moot question here is, if the revenue formulated question whether the tribunal is correct to invalidate the notice
under 158 BC.
158 BC. Your Lordship, remember that it is not as good as this notice under section 148 because it is a procedural. 158 BC is a procedural. Therefore, my contention is, suppose he has issued a notice. Date of issuance notice and product filing return is 20 days. But in fact, the notice has received. And
The only problem is this is a 2006 appeal.
Yes.
For 16 years, it's not even come up for admission.
That is, your Lordship, so many issues your Lordship come across, but it's a very question of law has to decide. Because I come across not one judgment of the Punjab Haryana. Punjab Haryana say even within the 15 days, the tribunal not justified to hold that the whole proceeding is vitiated. Not Justice Adarsh Sugul has rendered judgment, but it's a single judge. But this very issue has already been different. Tribunal also in favor of the revenue was passed the order. My humble contention is, if it is a procedural error, it can be rectified. And the petitioner, the appellant before this tribunal has not requested even before the asking officer to extend the time. And more so, he has filed the return after 476 days delay. Even assuming he has some difficulties, then he could ask before the asking officer.
Anyway, it's been pending for 16 years. After 16 years, now we'll start admitting the appeal.
There's so many years later on that we are admitting. Yes. It is up to your Lordship, but my stand is there.
You see, for the last 16 years, this appeal has been listed not even once. To now begin to admit the appeal and set it down for hearing would really not serve the ends of justice, considering the long lapse of time. Consequently, leaving the questions of law raised open for consideration some other appropriate case, the appeal is disposed of.
In this our opinion will be admitted.
That's right.
Supplementary list item number 2.
Lordship, I am appearing on behalf of respondent. Lordship. Name may be recorded.
All right.
Adiratman.
Item number 2.
Item number 2, I will Lordship kindly permit to withdraw with the liberty to if further cause of action arises.
All right. All right. Counsel for petitioner seeks you to withdraw liberty to file a fresh petition. Then he cause of action arises.
Much obliged, madam.
Round with liberty is paid. This is mentioned in the
Supplementary list item number 4.
Or my lord, never no instruction, my lord.
No instructions disposed of.
Supplementary item number 5. Supplementary list item number 5.
Yes, and this is regarding the employees of the High Court.
Only one issue is left, right?
No, two issues are left. They have filed an affidavit. Now this is pending on the administrative side. I'll have to take instruction. I'm told that they'll meet and give. So my lord may give me 4 weeks here.
All right.
I'll coordinate with the registry and take it.
At the request of the London Amicus Curiae. List on 18th April.
My lord.
Supplementary list item number 6.
It has become infectious.
Council petitioner states the petition has been disposed of.
Supplementary list item number 7.
My lord, this case may be adjourned 2 weeks after. My lord has initiated suo motu proceeding in this case. Since this case is a very sensitive issue. But
Whatever it is, sir. 1 minute. Let's just see what it is.
My lord, 11 persons were electrocuted.
1 minute. 1 minute, sir.
In this case, my lord has also already initiated suo motu proceeding, my lord, but I have to verify that case. That is the case.
No, this case has not even come up once, sir.
It is for first time.
First time it is coming.
Ah.
After 2 years, perhaps.
Yes.
The court has already started suo motu proceedings.
Yes, my lord. I have that is the instruction that is already honorable court has initiated a suo motu proceeding.
Then we'll pursue it in that, sir.
So
the counsel the petitioner states that.
But I have to verify if he has been initiated.
You can pass it over if you want to verify. We won't adjourn it.
My lord, I have to.
We'll pass it over. You can verify.
Where to fill in?
That as far as he's informed.
Yes,
the court has already taken up the same issue in suo motu proceedings. In that view of the matter, there's no need to entertain another PIL on the same issue. The petition is disposed of. All right.
My lord, with liberty, if not initiated, my lord.
That will obviously be there, sir. All right.
Supplementary list item number 9.
Item 9, my lord, the connectors, your lordship granted interim stay of that.
No, whom are you for, sir?
My lord, time and again, the government changed its previous order. Henceforth, the petitioner get justices. Henceforth, permit to withdraw.
All right. Counsel the petitioner seeks leave to withdraw this petition. Dismisses withdrawn. All right.
Supplementary item number 10.
May it please this honorable court. Sir, in this particular matter, the prayer sought by the petitioner has already been complied by OP number 2.
All right.
OP number
Counsel the petitioner states the petition has been rendered infructuous. Disposed of as such.
Supplementary list item 11.
11, your lordship. Kindly taken first week of March, your lordship. Yesterday, I injured in a road accident, your lordship.
All right. Counsel for the petitioner is stated to be in difficulty today. Defects be removed by the next date. List on 21st March, sir.
Oblige.
Supplementary list item 12.
May I please, Your Honor?
Yes.
The petitioner is a very poor person. Filing this writ application for regularization of service matter. The petitioner voluntarily joined on as a peon on dated 7th September 2006 in the counseling center Family Court, Kotak, without any remuneration, working since last 15 years, my lord. Due to shortage of court staffs and the said court unable to provide staff peon for assisting the petitioner.
We'll ask them to treat your. This issue must be coming up in other courts as well then.
He is working voluntarily.
Sorry?
He is working voluntarily.
Voluntarily?
Yes.
There's nothing like that. Obviously, his services are required.
Page 3, paragraph 3 of the writ petition.
You're voluntarily working means what? They have not engaged you?
No, my lord.
Then? If you're voluntarily working, there's no letter of engagement, then how do you expect any relief?
I have given a representation, my lord.
No, no, no. The court must have engaged you, then your representation will work. If on your own you're performing services, I don't know how you can expect to be regularized.
No, in this regard, Annexure 4, Annexure, my lord, 3.
That's only a represent. Is there any letter from the establishment to you?
No.
That's not possible there, sir. If the establishment has not engaged your services, we can't possibly ask them to regularize you. That's simply not possible.
My application may be considered, my lord.
No, 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 no. You say the establishment has not engaged the petitioner. It appears that he voluntarily offered his services. In the circumstances, the question of considering his request for regularization does not arise. The petition is dismissed.
Supplementary 13.
13 all same, my lord.
Same.
Supplementary list item number 14.
May I please, my lord?
Yes.
My lord, in item number 14, the petitioner challenges the issuance of notice under section 148 on the ground that the approval is not accorded by the specified authority that the commissioner of
List on 7th March, no course of steps till then. All right.
no, we have already, my lord has already decided this matter in a bunch of cases on the read petition where he has quashed that if it is page number 15 may kindly be looked into.
Well, that is not covering to that case, my lord.
Yes, WPC number 20919 of 2021 decided on 21st of 4, 2022, where the my lord has held that approval has to be given by the commissioner or chief commissioner, not by joint commissioner or additional commissioner.
No, that is that, my lord. Another, my lord, inquiry, another ground, my lord, in 148A, that is the another ground. Inquiry has been taken or not within 3 hours, my lord, 3 hours.
No, but what about this ground that is not authorized by the
Is, my lord,
competent?
Annexure 1 says, my lord, joint commissioner, which is not competent. Well, that is as per the.
Then it has to go on that ground then. What is the date of the order, sir?
My lord, that is on 21st of February.
21st of April, my lord.
21st April, 21st of January 2022.
All right. Inasmuch as the impugned notice dated 6th May 2020 under section 148 of Income Tax Act 1961 in this case has been issued under the authorization of the Joint Commissioner, CIT Range Rourkela, who is not the competent authority. The impugned notice is quashed. This is the same conclusion reached by the court in its order dated, noted down, in so and so.
24/1/2022 in WPC number 20919 of 2021 and batch of cases.
All right, and batch of cases. The retribution is accordingly allowed. No orders is to cause.
Obliged.
Supplementary item number 15.
My lord, in this case also the petitioner challenged the notice under section 148 on the ground that it has been issued after 6 years. That is barred by limitation.
Not this. It is to be noticed because competent authority has given permission. CIT has given permission.
No, but the notice is 30th March.
Yes, but we are taking the help of the government of return notification of extension time. There will also be issued notice and grant stay in this type of cases.
My lord, it is beyond 6 years, cannot be issued. The previous.
That's what. This is 30th March, sir.
No, you're not
No, for notices issued after 1st April, we are keeping those matters. This is issued on 30th March.
Yes, if 30th
March, it's covered by that order.
No, your lordship has passed order where there is no permission from the competent authority.
No, that is one set of cases.
Yes.
In another set of cases.
Another case, your lordship has not.
No, I have not accepted the plea that you can rely on that other act.
Surplus 6.
We have discussed that in detail in that order. In fact, your submission on 292 BB has been rejected.
No, milord.
On that other act has also been rejected because that act was not meant to cover these kind of cases.
148, not 6 years.
This is after 8 years, so that also goes.
But 149C, your lordship, that your lordship, I pass your lordship has issued notice on these type of cases. You're not in disorder. Lord, what I remember.
No, no, 30th March. This is not, this is prior to 1st April, sir.
Lord, sir, I'll take instruction in this matter.
No, no, no.
Yes,
All
sir.
those matters were before, the notice was before 1st April.
Yes, your Lordship.
You have dismissed it.
Yes,
This is also, this is 30th March.
Yes, your Lordship dismissed that, dispose of that in two grounds. One is limitation, other is permission. Competent. That in two grounds, your Lordship has disposed, not in this type of case. In this type of case, your Lordship has issued 2 and 3 cases notices. That is where a submission Lordship issue notice, or else not one day instruction. I'll take instruction in this case. The first time it's registered. Because subclass 6 says, Lord, if 4 years, but not more than 16 years of lapse from the end of.
But this amendment itself is from 1st April, sir.
This is not with effect from 1/7/2012. It is relating to year assessment of 13-14. The amendment not.
By which act? By which act was this amendment made, sir? 16 years.
16 years for if you have an asset outside India. But
yeah, this is not outside India.
Yes. You know, Milord, he has not asked for information. Milord, it is within he has not asked for whether it is inside the India, whether this.
No, he knows whether it's in India or not. He's the SSP, sir.
I don't have any asset outside India.
But I only take one instance. Milord, I humbly pray.
What's the point?
Milord, otherwise, I will not. Milord, I would take instance in this matter.
Okay, at the request of counsel for the department. List on
14th, similar matter has been posted, my lord.
14 March.
Yes, sir.
Oblige.
March.
Oblige. Oblige.
Supplementary list item number 16. My lord, item number 16, my lord, I have challenged the annexure 1, my lord. The notice issued on 31st March 2021, my lord. 148 notice. And my lord, the page 13 may be seen that the regions, the last para. As per the information available, assessee received such amount by way of sale of share, which is not shown in the ROI, return of income. My lord, kindly have a glance to the page 11, annexure 2. That is filed on.
No, this is joint CAT, sir.
Let it come.
Is enough. It's covered by that order.
My lord.
Who's appearing?
My son, Mr.
So
Chimanga.
it's covered by that same order, sir. In as much as the impugn notice dated 31st March 2021 under section 148 has been issued, only with the authorization of the joint CIT range 1 and not the Commissioner of Income Tax. The impugn notice is hereby quashed. All consequential orders are also hereby quashed. This order is consistent with the order dated 21st January, is it? 2022?
That order is.
Yes, my lord. 21 January 2020.
Passed in
24th January.
24th January.
All right. The writ petition is allowed with the above terms and orders.
Supplementary item number 17.
May I please your lordship? My lord, this is a public interest litigation petition, my lord, by the villagers, my lord. And as per annexure 1, page 13, the government land it is a government land, has been recorded as roads and used by the villagers, my lord. And in order to go to the burial ground and agriculture field. And my lord, the OP number 4 to 12 have enclosed the land. Your lordship kindly turn.
Or the petitioner's representations at annexures 8, 9, and 10 shall be examined by whom?
My lord, collector and Tahsildar, OP 1 and 2.
Can't be two things, sir. By collector Kendrapada, bracket OP
Collector
number 1,
Kendrapada,
and after issuing notice to the petitioners as well as opposite parties. 4 to 12.
OP 4 to 12.
After giving them a hearing. The order should be passed thereon not later than 9th May 2022 and be communicated to the parties not later than 16th May 2022. The court clarifies it as not expressed in the matter.
Supplementary item number 18. Supplementary list item number 18.
None appears. This is not possible.
Supplementary list item number 19.
Your Lordship, on behalf of Mr. Das, I beg for an adjournment of 2 months, 2 weeks.
For what?
The council is sick.
Counsel for the petitioner stated to be unwell. The text will be removed before the next date. Just on 10th May.
Copy of the writ petition be served.
Copy of the writ petition be served on. That's the defect. So anyway, yes.
Supplementary list item number 20.
Lordship, item 20, Mr. Lord Senior Counsel, Mr. H.S. Pulka, my lord, is on BC.
My lord,
Yes, Mr. Fulka.
my lord, my apology, I am not present physically.
No, please.
My lord, this PIL raises two issues.
Yes.
One is in the Orissa victim compensation scheme. There is a clause barring all the offences covered by SC/ST Act.
Okay.
And only, my lord, no other state has such a clause. Only Orissa victim compensation scheme has, and Manipur has. All other doesn't have this bar. And this is against, my lord, the provisions of the Act. Second issue is, my lord, the implementation of the provisions of the SC/ST Act regarding the relief to the victim itself. My lord, in this case, the FIR is of September 2019. And my lord, shockingly, not even a single paisa compensation or relief has been paid to the victim till now. She has given even birth to the child, my lord. The child has died. My lord, may kindly see the clause, my lord. Page 22 is the Odisha victim compensation scheme.
Is it possible that this exception was issued because there is a compensation provided for in those acts itself?
That's right, my lord. But the SC/ST Act says that this relief under the SC/ST Act is in addition to all other laws.
Correct.
And so therefore, none other state has this bar.
Okay.
It is Orissa which has the bar, so it is contrary to the specific provisions of SC/ST Act, my lord.
And anyway, the SC/ST compensation has not been given.
Even that has not been given. My lord, can you
just issue notice, Mr. Fulka will just issue notice.
So blind, my lord. So.
All right. Mr. Muduli accepts notice.
Yes.
And states for 1 and 3, and states that he can accept for 2 also, for the opposite respondents, opposite parties.
My lord, may I make?
The compensation to the victim should be disbursed in terms of the SC and ST rules, right? 1995, Rule 12 of the SC.
12.
Forthwith, a direction is issued to the Secretary DLSA, Koraput, to ensure that this takes place before the next date, in coordination with the local administration.
My lord, may I make another request? My lord, it shows that the legal aid councils are not active there. I am sorry to say so.
No, we are getting them active, but maybe this one issue they probably are. We'll find out what has happened.
There may be many other cases of this kind. For 2.5 years, compensation, no relief is being given. My lord, this is very, very.
No, this will, I think, alert them to this possibility of lapses. All right. List on 23rd March. So we'll make sure she gets it by then.
So grateful, my lord.
All right.
So grateful, my lord.
Reply be filed within 3 weeks, rejoined for the next date. All right.
So grateful.
Supplementary list item number 21.
Now is Mr. Dalai here? Come, please come. So where are your reports? Where is Mr. Jena? There he is.
I've prepared my report.
So there is also another petitioner. Come forward, please. Let us speak also. So we already have enough petitions on board, Ms. Panda. We already have 3 petitions on board. So why should we entertain one more? Why don't you give whatever details you have to these gentlemen? They'll.
Sir, I just returned back from Dhinkia the day they visited, and I think there are many things that have not been brought into your notice. And it is very important that because I was inside the mob and I was about to be lynched. And I don't know how I came out of that mob. And I deserve to be heard by you, sir. And I deserve some sort of a justice, not only for the people of Dhinkia, but for all the movements that are taking cross in Orissa.
In fact, some of them were highlighting this when they made their submissions last time. So we've asked for them to submit their reports. I actually wanted a joint report. I don't know if it's a joint report.
Your Lordship will appreciate. Yesterday, we had a discussion with all the committee members, and apparently there was no consensus. So we are submitting reports independently. Our report is this, and they will submit their reports. If your Lordship will direct, I will serve a copy of my report to them, and any date may be fixed for further hearing.
Have you met any of these councils before?
Yes, I have.
Yes,
met-
she had to Dinkia. She had gone to Dinkia with Mr. Devdas on that day, and Mr. Devdas introduced us that she is so and so a social worker.
No, I don't think we need to multiply. What I'm saying is, whatever concerns you have, if you can share it with them, they are representing the people anyway.
Your Honor, I've already shared those concerns with Omkar Devdas.
Yes.
And all of them have been a party to what has been happening out there and what happened to me.
So if
I really don't have to say more about it. But I think this is my day in your court.
No, not that way.
So,
See, the
sir,
point is,
please hear me out, sir.
No, I will. There's no problem on that. But we just want to tell you that in PILs, the essential approach is non-adversarial. All right. But we can't avoid adversarial proceedings if there are differences in perceptions. But within the problem arises if within one side there are going to be differing perceptions. And that might actually undermine the effort of the petitioners. So you shouldn't bring it to a point where you start contradicting your own people on the side of the people.
I'm not, sir, because if you look at my PIL, it very clearly talks about the Supreme Court direction in Tehseen S. Poonawalla versus Union of India, where certain directions were provided to all the states to ensure that police brutality and police atrocities are duly addressed by the states through establishment of certain systemic norms and standards. So for me personally at this level, I think mine would add to the reports that are being presented by different advocates out here. So I don't think I'll be adversarial, or I do not intend to make it adversarial, because for me, it's very important that I place the very fact that the state still has not adhered to the norms and standards and the directions that have been set by the Supreme Court, and it needs to immediately take into account and set up these norms and standards.
In fact, you were yourself mentioned in this report of Mr. Devdas. There's a whole paragraph. I think you can share your report with her if you don't mind. Just share it with her. You don't have a copy. Just share a copy of the report with her. No, tell us what actually happened in terms of escorting people back to the village.
That has not really happened, my lord.
No. Could you give a list of such persons to Mr. Mohanty?
My lord,
I had in my last order, Mr. Jena, asked you people to furnish a list of such persons, right?
Yes, my lord.
Who needed to be escorted back.
Yes.
I've already served. I mean, 4 or 5 days back, I have served the
My
order.
lord,
Lordship passed the
let me
order.
reply to this. Mr. Jena has given us a list of persons who are willing to
85.
come, and 85 persons. Now I sought for a report from the police about the status of this. They have given the report today, just now I have received, that the village committee has reported to the IIC that out of these 85, 74 are now inside the village, staying in the village. 11 persons are not coming because there are cases FIR registered against them. This is the status.
No. What is your verification?
That is the
Villagers saying
verification.
one thing is
Verification through the local villagers, and the villagers have, because we have to inquire.
My assessment, as far as I am concerned, there is visible fear in the villages.
No, 1 minute. Let us first go step by step.
My
sir.
lord, my lord.
Mr. Jena, why don't you take a copy? Why don't you give a copy to Mr.
Yes,
Jena?
my lord. Just now I am giving you. We'll give you all the.
But today
No,
morning
no,
I
if
got
11 persons have FIRs, can you give us names of those, numbers of those
They
FIRs?
are not coming to village because they are apprehending that they may, either they will surrender to law or they
No,
can
no,
get.
are they named in an FIR?
No.
Those 11, if they're not named, then where's the question of they're being
Yes, they are
arrested?
named. They are the direct accused.
No, no, no. Where is the copy of the FIR where they're named?
I will provide that.
That
11
is
persons.
important. Mr. Bonti, this was what was told to us last time. Most
Yes.
FIRs give 2 names or 1 name and say 300 others, 400 others.
Yes,
I will submit before a lordship how those 11 persons who are not coming to village, how they are connected with the cases and what is the material against them, whether they are named in the FIR or any material has been collected against them, evidence is there against them so far as their involvement
give
in
a
the
copy
crime.
of this. What
Yes, I have already given the copy.
My lord, there are cases where the persons whose name are not referred in the FIR, they have been arrested after 14.
That is different, sir.
That
Then the law will take its course
lord,
as far
I
as the. We are now on people who perhaps are not named in FIR and are still not able to come back, correct?
Well, not only that, my lord, 19th incident, the persons who have been assaulted, my lord, against them
Then
3
an
FIRs
FIR
have
has
been
been
lost. 3 days after. Police was there himself. The video clips are available. The assailants can be identified. No FIR from the side of the police was made. And after 3 days, my lord, on 21, to my instruction today morning, now they have lost 3 FIRs against the victims who have been assaulted.
Yes, my lord. Including petitioner in item
My
number
lord,
21.
somebody lodging FIR against relating to some occurrence and it makes out a cognizable offense. It has to be registered. Not that they are arrested. Anybody has been arrested. That is not their case.
Mr. Katke, even you and Mr. Monty can't give a joint report, it seems. Even both of you can't give a joint report, it seems, I said.
No, we are joint. We have given the joint
report.
Yes.
All right. I see. All right. See, yes, Ms. Panda, there's a whole reference to you in the report.
Yes.
So
yes,
what we suggest is this:
so
instead of entertaining more and more petitions, if you want to participate by assisting Mr. Devdas, by all means you can do it. I don't think he'll have any objections.
So that I'm leaving.
And whatever you want to say, we'll hear you. You file whatever you instruct him. He will file papers, and we can hear him. There's no difficulty at all.
Thank you so much, Your Lordship. I just have 2 things to say. One is this is the pen drive which contains the mob lynching that took place.
So you file it with an affidavit. So this is what I insist on people.
I've already filed it. I've already given it to them.
So let them file an affidavit, and we'll give a copy of the affidavit with the pen drive to the other side.
Yes,
All right.
sir. And Your Lordship, I sat with the villages and took out all the names of the people who were a part of the mob lynching, and I have documented their names down here. So these are the 2 things I would like to put it across so that they can include it in the report.
So first you say Sarita Barpanda, the petitioner is present in person and states that she was present at Dinkia village on 19th February 2022 during the visit of the 5-member committee of advocates. Full stop. The experience undergone by her is narrated by her in this petition. Full stop. It finds also mention in the report submitted to this court today by Mr. Omkar Devdas. So the court has therefore requested Ms. Panda to provide all the information she has to Mr. Devdas and the submission she wishes to make on the issues incidental to the happenings in village Dinkia can be shared with Mr. Devdas, who can then present them before the court. Full stop. She further states she has a video clipping of what transpired on 19th February 2022 and has handed it over to Mr. Devdas. He is permitted to file an affidavit placing the said video clip on record.
Sir,
An affidavit of Ms. Barpanda placing the said clip on record with an advance copy to Mr. Devkanta Mohanty and Mr. Katkia, learned additional government advocates.
So, sorry, sir. Just one more thing I wanted to bring to your notice. I was the one who was beaten up. I've fractured 2 of my fingers in this hand.
So you can file a complaint with the police.
Sir, 2 days. I've already written a complaint. 2 days later, FIR was filed. 3 FIRs have been filed against me.
No. There is no FIR with you as a complainant, you mean?
I have filed a 0 FIR, but the police in Dhinkia has filed an FIR, 3 FIRs against me.
All right.
And these FIRs, though they have not been able to take my name correctly, Sarita is there, but my surname is something that they have not been able to spell. But these FIRs primarily say that I have been actively breaking the law out there in Dhinkia.
That will be examined at the appropriate time, not worry. You see, in view of the above, in that view of the matter, you say the court does not propose to entertain another PIL on the same issue since there are already 3 petitions in this regard before the court. The petition is disposed of in the above terms. Then in the other 3 petitions, you say we have before us today the reports submitted, separate reports submitted by Mr. Prashant Kumar Jaina, Mr. Omkar Devadas, and a joint report of Mr. Devkanta Mohanty and Mr. Janmejaya Katkia.
And Mr. Dole has also submitted.
Oh, Mr. Dale has submitted a separate report. Where is your report, Mr. Dale? Oh, it's this. Right. Correct. These copies of the reports have been exchanged among counsel.
Yes, that may be exchanged amongst each other.
Correct. You say,
my lord, your lordship may kindly note the letter which I have filed. That is the letter of the IIC Abhachandpur regarding inquiry of member of Dhinkia village, where it has been reported that out of 85-7, that report.
I was just going to dictate that.
Yes.
Mr. Mohanty is also placed on record. Copy of a letter dated 22nd February 2022, written to him by Mr. Jeevananda Jaina, IIC Abhachandpur Police Station, regarding the 85 persons in the list provided by Mr. Jaina to Mr. Mohanty, who were apprehending arrest and threat to their safety and were therefore not returning to their villages. Paragraph, as per this report, 74 of the 85 persons are now residing in their houses with their families, and the remaining 11 are said to be single quotes evading arrest, unquote. Full stop. Mr. Mohanty, on inquiry, states that on the next date, he'll place copies of the FIRs where these 11 persons have been named or materials to show their prima facie involvement.
Yes.
What is the current position in the villages now?
My lord, may I submit one?
They know.
Yeah, let him say and then I'll
Yes. They quite well knew that we are traveling to the village by way of order. They obstructed our vehicle. I don't know, probably two vehicles carrying the AGA and my friend Sukant, probably they allowed them. Our vehicle was stopped. And they came, peeped at the doors, and thereafter searched something. Then when we disclosed this, they allowed us. And when we reached, my lord, just beginning to hear the people, some people were gathering there. Then, my lord, persons who came
Mr. Jana, what happened on 19th, we'll definitely hear you at length. I just want to know the current position in the village.
Let me
village, the persons who have been opposing the establishment of JSW,
yes,
they are in a fear-stricken state. Their movements, their expressions, they are not allowed to move through the village. They wanted to come to express their views before the committee, my lord. They were not allowed. They were in front of the police, my lord. They were lynched like anything, my lord. They were beaten, brutally beaten. Those people came
And all video clips are there. It's not that, and it find place in our report. And this, our friend Milord Badaponda, probably she took a brave step by all efforts to rescue the person. Otherwise, the person would have probably would have been injured badly. Milord. That is there, Milord. This is the state of affairs. Somebody coming to meet this committee members, Milord, how somebody can obstruct in presence of the police, Milord. And we have given our suggestions and findings, Milord, so far as how the police is knocking at the doors of the villagers in the midnight, how it is threatening, don't give anything, any report to the committee members. He wrote, the IIC wrote in the blackboard, you say something, unless you say these things, you'll be booked in false cases, Milord. These are all ladies, old man, all these people.
And these persons have named the persons, the IIC name, that he regularly threatening them.
No, I might be opposing. Some people might be opposing the establishment or in favor. But how can police and the administration curb their voices? This is right of expression, movement. So how can this be?
Yes, Mr. Mon.
Lord, may I submit only few words? Actually, in village, there are two groups. Majority supporting establishment of industry. Some people opposing.
This group supporting the setting up of the industry.
Yeah,
has this group been there before or it's come up now?
My lord, belong to that village itself. They're all villagers.
No. When did this group emerge? Because from whatever we read,
this established when they knew that the industry is going to be established, and some people, it is quite natural, my lord. Some people will oppose, some people will support, and there is a hitch between both the groups. Only thing is that what I have mentioned, the persons or the group which is supporting the.
There is a Gram Panchayat here.
My lord?
Is there a Gram Panchayat?
Yes, that. Yes, Gram Panchayat, the Sarpanch, I have examined this, I have mentioned in my report, the Sarpanch, ex-Sarpanch, everybody is saying that what has happened. Only one line I will say.
Saying what?
It says that that is what I am submitting. Some people, all the persons are saying, majority people, that some outsiders.
No, 1 minute. Outsiders are doing what?
That is what I am submitting. Some outsiders, NGO and social work activists, they are coming to village. They are instigating this group of people that you oppose the establishment of industry, and they say that you cannot come to our village and do all these things. That is the reason for which there is quarrel between the groups.
All right. No.
I have mentioned in my report.
Let's try and analyze the statements that you're making. You started by saying there are two groups.
Yes, ma'am.
So which means that group which is opposing the plant doesn't need any instigation from somebody else?
Well, doesn't need any
instigation. There is already a group opposing.
No, they are instigated by NGOs.
Sorry?
They are instigated and
no, which means there was never any opposition according to you. Let's get this clear, because this is the stand of the state.
Yes, ma'am.
What you are saying before the court is the stand of the state.
Yes, ma'am.
As state, you're saying not a single person opposed this in that village.
No.
You're saying or you're not saying?
That is not.
You started your submission by saying there are two groups.
Yes, ma'am. That is also there in my report. Also.
Correct. So one group that supports the project, one is opposed to the project.
Yes, ma'am.
That group which is opposed to the project was never opposing it earlier. It is opposing only because some NGOs landed up.
They are guided by these NGOs.
No. There's no question of anyone guiding, please. Let's be clear on this. Villagers were there from the beginning. In the village, there have been two groups. Isn't that correct?
Yes, ma'am.
According to you, there are two groups.
Yes, ma'am.
What was the stand of the Gram Panchayat? What is the local administration? What is their stand in the matter?
So far as the present Sarpanch is concerned and ex-Sarpanch is
concerned. No. Has the Gram Panchayat actually discussed this in their meeting?
No, the Sarpanch has stated before us, before all the committee members.
No, Sarpanch by himself can't decide, right? If a Gram Panchayat has to pass a resolution, it has to meet as
so
a Gram
far as
Panchayat.
resolution is concerned, we have not obtained any information from. But Sarpanch, he was examined, he stated before the camera, and ex-Sarpanch also. Both of them said that the outsiders are coming and instigating some.
Are these Sarpanches and ex-Sarpanches supporting the project or opposing the project?
Supporting. They are supporting the project. They are saying that some of the few people of our village, they are opposing it and they are creating all these disturbances at the instance of some outsider.
Has the Gram Panchayat actually considered this issue?
That I have to take
No,
instruction.
no, when this project was cleared, were the people consulted?
Yes,
Let's
that
go
was
back.
a public hearing. That was a public hearing was there.
Public hearing has been done.
That I will file, that is the submit records to that effect. There was a public hearing.
No, when did the public hearing?
No, my lord, public hearing has not been done.
No EIA, no EIA clearance, my lord, as on date, to our information.
No public hearing has ever taken place.
Are you sure of this, Mr. Mohanty?
My lord, may I ask the?
Yes, yes.
Yes.
Public hearing.
We will file documents with regard to the public hearing conducted by the district administration.
When was it conducted?
My lord,
When was it conducted, please?
in 2019, what he is saying.
So, which date in
21.
2019?
And in 21 also, another. I will submit the records,
No, my lord.
let us know, my
No.
submission,
Okay.
let
All
us
right.
know.
The second
Kindly-
question, is, of course, you will file an affidavit on the public hearing.
Yes, my lord, we will file that.
No.
We'll file
Is
affidavit.
there a statutory EIA clearance given for this project?
No, my lord, not given.
I'm asking him,
Sorry,
sir, I don't
sorry.
know, what is your problem?
Sorry, my lord.
In that regard also, I will submit the affidavit regarding EIA clearance.
No, what are your instructions? Was there clearance given, not given?
I will.
No, how can an IAC not know these basic facts? There's something, it's very surprising.
No, these facts are actually dealt with by the collector, the district administrator. Your lordship may give me only 7 days time, whatever direction will be, I will comply and file the affidavit.
See, the resistance everywhere is when people are not consulted. This is the problem. The genesis of all these problems is when people on the ground are not consulted.
Yes.
Their views are not taken into account, and suddenly they find something happening around them, there's a resistance. And this is not the first time in Orissa. Mr. Mohanty, you have,
Yes.
Is this the first time it is happening in Orissa?
No, everywhere.
So what has the state learned from the past? What have you learned from your previous experience? This is not the first time you're facing this?
No, in every
So
project.
is there no learning from the past? How do you take people into confidence?
My lord, in any case, some people will certainly.
No. See, nothing happens in thin air, right? You have to get down to the bottom of it. In the manner you conduct your public hearings is one thing that you have to ask yourselves. Because we have some other petitions from other regions. The refrain that we are finding is this public hearing did not take place. We were not allowed to speak at the public hearing. We were not allowed to participate. This is not just in this petition. I think there are at least 3 or 4 petitions from other places. So there is some serious issue on the holding of such public hearings. How do you make it safe for people to participate in public hearings? And how do you minute it? How do you record it? All that matters.
Nowadays, your lordship knows everything is videographed. So
that is what is going to happen. You will also get videographs. You will also going to get a series of. There is already a clip in here.
I will file specific.
All right, this is interesting. So there are videographs of those public hearings.
No, I do not know. I do not know. I am sorry. So far as this is concerned, I have no idea. My lord, may kindly appreciate we are now in the stage of acquisition of land. Plant has not yet been started. Only acquisition of land. 3,000
But
acres.
if this itself is going to become so controversial, even 3 advocates cannot visit the village without there being a law and order situation.
I think there is no obstruction on the part of the advocates.
No. What happened at the presence? Look, I've only glanced through these reports. Clearly, the visit was not some very peaceful visit.
They are escorted by the police van.
No, I am sorry. Please don't say like this. Escorted. Police was very much there for everybody.
Different route.
They have taken a different route. And both of us and Mr.
All right, Mr. Mohanty, in your presence, was it all very peaceful and calm during a visit, or there was some commotion?
And even plus, beg pardon, my learned friend told me in the last evening that there should not be a presence of any police. But there he understood what was the requirement of presence of police. Only one section of police was there.
No, whatever, Mr. Kashtia, therefore, what comes across is the visit by 5 of you was in the midst of some commotion. It was not a peaceful visit. So let us, at least on something, you have an agreement.
And I have tried my best to convince my learned friends to come to a consensus, but it is not possible.
No. Consensus is something about what? See, the question is, if people find you have gone to make some fact finding on at our instance, if even our order doesn't ensure that you do it peacefully, there's something wrong, isn't it?
Of course, yes.
Basic law and order is whose responsibility? It is the state's responsibility.
Yes.
Can 5 lawyers cannot visit a village to find out facts without there being a commotion?
My lord,
Is it so? Is it a situation like that in Orissa that even 5 lawyers cannot go under orders at the High Court to find out facts?
My lord, may I respectfully submit, so far as the lawyers are concerned, I think there is no obstruction on our part. They amongst themselves, there was some quarrel between 2 groups and we are present there.
Now that you know the groups now, the IAC knows the groups now?
No, that is also
No, 1 minute. The IAC knows the groups? Without one group obstructing the other group, we will ask the lawyers to make another visit to visit each of the groups. Let there be a peaceful visit. All 5 of you will sit together. They'll organize a hall or whatever. One group will come and make its presentation. Next, demonstrate to us that you can do things peacefully there.
Yes.
We are not going to stop till there is complete peace in the village.
Yes.
And people's voices have to be heard. It can be a voice supporting the project, can be a voice opposing the project.
Yes.
Nobody, see, in a democracy, everybody has a right to voice opinions.
Yes, ma'am. Yes.
Nobody should use force to say, I will not let you speak.
That cannot.
So that is some basic thing as a police we have to ensure. See, if the rule of law is to be maintained, police must make sure all voices are heard by a committee which is coming under orders of the court. That is absolutely essential. So when can we have the next visit? I'm still going to insist on this so that there is peace. People are able to speak without any fear. No shouting out the other person, no roughing up the other person.
Your lordship may observe that in that order so that we can, that can be.
You should learn to anticipate. This is something I've not understood. How can you not anticipate? If you knew from beginning there were 2 groups, this is what you started your submission with.
My lord, if the police will go and say something to them, they will allege that they are
No, now the orders of the court. You see, this is why we are passing orders. Why are we passing orders?
My lord,
if the police can't say High Court has asked this to happen and you cannot obstruct this, can the police not say that?
Yes, we will propagate that.
He's the IIC?
No, he is the additional SP of Paradeep.
So were you personally present on 19th? Ask him.
Yes, he was there.
And in your presence, all this happened.
In fact, Lordship, I'll say one thing, Lordship, because of his presence, we could rescue. Because his work is appreciable. He was not informed, but he did a lot.
No, then we'll not need, you need the SP level person to be there then.
But Lordship,
see, we will not stop till this happens peacefully.
Yes.
This is a test case. If in one village in Orissa, we can't have 5 advocates visit in calm, peaceful manner, then that's a real problem here.
But so IAC, Lordship, that IAC, Lordship, kindly see my report I have given. What is the real root cause, Lordship? What is the cause?
No, we leave it. We'll trust he's the
Lordship. He is the ACP, Lordship.
May I request one thing to your Lordship?
Yes.
Your Lordship is saying that we will go for another visit.
Yes.
But your Lordship may restrict it to the committee members. No NGO, no outsider. I have submitted in my report that how the outsiders accompanied us. How they came to know that is the date of visit of the committee members? Who informed them? They are all, your Lordship will go through my report, then I will not submit.
Is there a place where a hall kind of a thing is there?
Yes, there is a mandir premises.
All right.
No, that is not sufficient now.
Then where you will get it?
Isn't there a community hall or something?
No, there is no community hall.
No, he probably knows the.
There is a panchayat. Panchayat office.
Okay.
Yes.
So you organize a meeting, let there be sufficient representation of both groups.
Yes.
One group will not obstruct the other.
Yes.
They will come peacefully, speak to the committee and go back.
Yes,
And you
ma'am.
also
Yes.
sit, all five of you sit together, at least there you sit together.
Yes. And your lordship may
Let them
direct
not
your-
arrest me, Lord.
They are close together.
You know, people who are opposing, they are apprehensive of being arrested. That's why
Please,
till
please,
then,
all-
many of the people are outside hiding.
No, anyway,
outside.
he's given you that report.
But Lordship,
Yes,
go
I
to it.
have given the report.
Lordship, will permit Lordship kindly one sentence Lordship. In fact, what has happened there? There are two wings, means one district administration, one is the law enforcing authorities. In fact, while acquiring this lands Lordship, the law enforcing authorities have taken the all task. The collector is absent. The district
No, the
administration.
Tahsildar was present.
Please,
Tahsildar was present.
please let me complete. I am giving my opinion. In fact, the entire process is taken by these law enforcing authorities. That is the whole crux of the matter, Lordship, because that's why the pressure putting on the public, and those who are opposing, they have been threatened on gunpoint, and they have been threatened for arrest to them.
So anyway, in this meeting, we'll make sure that the collector is
Collector,
present.
Lordship, collector must be
Yes.
there.
Let the collector and SP be present.
Yes, my lord. Yes, ma'am. Obliged. Obliged.
All right.
So can I have a, so I was the one who was there during the meeting, and if if Sir feels that I'm an outsider, I belong to the state.
No.
So sorry,
I
sir.
don't think you should start reacting like this to
No,
them.
I'm not, sir. I'm just
No, it's all
sharing
right.
it.
It's all
And
right.
I've been working for Dinkia.
It's all
for
right.
the
We'll come
past
to see
17 years.
First, now we are concerned with the people's problems. All right. This petition cannot become something about you, please. We'll have to first deal with the people's problems. You have to make sure they are able to speak fearlessly. It's very important for us to do that. We'll address all the other issues one after the other. But we cannot convert this petition into a petition about how they should be treating, other persons. We'll first deal with it in sequential. First, we want the villagers to be heard. All right, whichever is the point of view. You may have 1 point of view, 2 points of view, 3 points of view. They should be able to speak without fear, without commotion. This is absolutely essential. You see, from the reports submitted to this court, there is by and large a consensus that there was commotion in the village during the visit of the 5 advocates. It is also clear that there were 2 identifiable groups of people, one opposing the project and one supporting it.
Yes.
Full stop. It appears that because of the commotion, the advocates were unable to properly interact with the people of the village. And the reports by and large reflect this situation. Paragraph. The Assistant Commissioner of Police, is it?
No, additional SP Paradeep.
Additional SP. Okay. The Additional Superintendent of Police, Paradeep, who was present on the occasion, is also present before this court today. Full stop. The court has impressed upon the 2 additional government advocates and the ASP that when advocates visit pursuant to an order passed by this court to gather facts, they should be able to do it in a peaceful and calm atmosphere. And the villagers should be able to speak to them without fear or intimidation by anyone, and in particular groups who may be opposed to their point of view. Full stop. In a democracy governed by the rule of law, space must be provided to express views which may be opposed to each other in a civil manner. Full stop. It is the primary responsibility of the police and the local administration to ensure that a peaceful atmosphere is maintained in the village to enable this to happen. Full stop. Since this was unable to take place on 19th February 2022, the court directs that there will be another visit by the committee of 5 advocates. That is the 2 additional government advocates and the 3 advocates, Shri Sukanta Kumar Dalai, Shri Prashant Kumar Jena, and Shri Omkar Devdas, to the village Dinkia. At this meeting, which will take place in a place specially to be arranged in the village by the local administration, the collector Jagat Singhpur and the SP Jagat Singhpur will remain physically present. Therefore, this court is not fixing a date, so that an appropriate date within the next week. That is it okay with you people? The next week?
Let's fix a date so that next week, by next week. So that we will be ready on that day and the administration will be ready.
Saturday is
Convenient.
convenient.
All right. Do you want to talk to the collector and SP that Saturday is convenient? Then it should not go beyond Sunday then. It should be either Saturday or Sunday.
Your Lordship.
Yeah, okay. The next meeting which should take place either on a Saturday or a Sunday. That is 26th or 27th February 2022. In which the 5.
My lord, on 27 there is counting of 27 and 28 counting of votes.
Which is why I asked. So you tell us a date. You tell us a date.
1 week after next Saturday.
All right, which is what, 4th?
Because by that time the panchayat election will be
5th March. All right.
5th March.
All right. On 5th March 2022, on which date the 5 advocate committee, members of the committee, the 5 advocates will sit together.
My lord, may indicate that panchayat office is the panchayat office of Dinkia. That I think my lord friend will not disagree.
The sarpanch and other members of the Gram
Yes, all
Panchayat
elected members
will
of-
also remain present at the
Yes,
hearing. Both groups of people will be permitted to come and place their views, with it being ensured that one will not obstruct the other. Full stop. The meeting be videographed.
My lord, the collector may be directed to organize all these things.
Yeah. The arrangements shall be made by the collector Jagat Singhpur, who will file a report of the meeting before this court before the next date. Full stop.
The meeting should be confined to the villagers only, not NGO members or outsiders, social
No,
workers.
who do you identify as
Yes, so
outsiders?
they-
Who do you identify as
It
NGOs?
can be identified. The Sarpanch can identify. The Sarpanch of that Dinkia village, he can identify whether
This
he
may be
belongs to.
confined to the Gram Panchayat, my lord.
Yes.
Dinkia Gram Panchayat.
Gram
not
Panchayat,
Dinkia
yes.
particular village, because people are affected of the
Okay,
Panchayat.
okay, Dinkia Gram Panchayat, okay.
Yes.
My lord, may I request, I belong to that same Gram Panchayat. I belong to same Gram Panchayat. May we allowed to participate in this meeting?
See, this is the thing. So if you're going to allow everyone to participate, then you can't ensure that, correct?
No, my only submission is that these NGO workers or outsiders should not be allowed.
See, the outsider-insider concept is problematic, Mr. Mohan.
No. What I beg to submit, outsider, I mean, your lordship can know very well what I mean. Because anybody of the Dinkia villagers, Dinkia Panchayat can come and participate in the meeting. That cannot be restricted. Dinkia Panchayat members.
See, those opposing the project and those supporting the project are also getting support from everyone.
Yes, lordship. Lordship,
That's what I'm saying.
Lordship,
So then there is a problem there.
But I don't, they are also not allowed to.
No. So we'll say that the villagers will be heard.
Okay. Villagers will participate and will be heard.
Yeah.
Only participate.
Lordship, another line, Lordship, all the military protesters are objecting because last 2 days police were threatening not to adduce any statement before the committee. So no suits threatened should be from police. Lordship.
No, but we can't.
These are all things
Lordship,
which my
no, this is the statement in presence of you.
Mr. Dalai did a great thing on that day.
I think Mr. Dalai, one is the positive statement which you've just made in the order that they'll ensure a peaceful atmosphere.
Lordship.
Negative statements always cause problems.
Lordship.
Yes.
Lordship.
My lord.
One prayer, my lord. The reason for taking outsiders, Mr.
You don't start calling them. See, the whole point, these labels are the problem, I say.
My lord.
You yourself start using these labels as a problem.
My lord, may I submit one thing? Through local administration, we will make awareness in the that this committee is coming on such and such day. You kindly come and participate in the meeting.
Yeah,
peacefully.
Yeah.
Through mic or by any other means.
No, but that's up to you because we leave it entirely to the local administration to facilitate.
Before your lords. I'm just placing before your lords.
I have already said the meeting be videographed and placed on affidavit of the collector. Placed on record with the affidavit of the collector. The collector and SP will remain present in virtual mode on the next date.
Yes.
To address the queries of the court.
Yes.
The report we filed within 3 days of the meeting, that is positively on or before 8th March 2022, with advance copies of the report and the video clip to the 5 committee advocates.
Yes.
List on 10th March at 2 p.m.
Obliged.
All right.
My lord, one thing, my lord, the lordship may clarify that Dhinkia Gram Panchayat, it will cover all the villages around. Under that Gram Panchayat, that is going to be affected by the. That is already not only Dhinkia, because the disturbance started in this is
the whole Gram Panchayat.
Whole Gram Panchayat.
Something. Okay. 11th March. 11th March.
That is written, Mr. Jana. That is Dhinkia GP area.
Dhinkia Gram Panchayat is what it says. Right. All right.
Can I make a small prayer, my lord? Can my associate be allowed to assist me in
No,
radiographing
sorry.
all this?
Then I will say my associate, he will say my associate. Sorry.
Lordship may realize
I
the
request
difficulty.
your lordship not to allow all this.
Your lordship may realize the difficulty. We will
No,
be
no.
busy in interacting with the people. My associate may take a photograph, videograph, or
No,
note down.
everything will be
What is wrong in
videographed by
it,
the
my lord?
district administration
What is
from
wrong in it?
beginning to end.
No. To assist me, if my associate go and note down something what happens without causing any
My lord,
disturbance
he is a
or
part of the
interfering,
committee.
what is wrong, my
And-
lord? Because that issue arose last time because some of the
Why he is insisting for his, so all of us
No,
will
not
take our
insisting,
seniors.
lord. It's a practical.
Okay, we'll do one thing. I think for 3 of them, we can have one person assisting all the 3 of them. See, it's a practical problem. When you're sitting in a place.
Then only advocates, juniors.
That's what he's saying. You're talking about advocates.
Will direct that. No private individual, only advocates.
No private.
They are juniors.
All right, they'll give you the names of the advocates who are going to accompany them.
They will issue names to us.
It will be 2 more. I think 2 more advocates is fine to assist you.
Difficulty is we can't ascertain who is supporting the movement, who is not supporting.
Now you'll get to know. Now you should get.
That is why we had independent observers who have been working in there.
But now you'll get to know. Now that he's made it clear that there are 2
We
groups.
vehemently oppose. That is the root cause of all this.
All right.
That is the root cause.
So you say the 3 advocates will give names of 2 of their associates who will accompany them.
Yes. Associate juniors. And then
Associates oblique. We don't, some don't like to call them.
Associate advocates.
Yeah, associate advocates, yes.
No, not associate means it may be non-advocate.
You should feel, you have the might of the state with you. You should feel confident now.
No,
You
why
should
I
say,
am submitting.
whoever is there, it will be a peaceful.
Why
day.
I am submitting all these things.
I know it. It's all right. So Names of two associate
Lordship is
advocates.
allowing then three, Lordship from three, because my, all the petitioner advocates of this bar. So Lordship allow me three.
Why?
Because we are, there will be
ହେଲାନି ଆପଣ
dispute.
ମିଶେଇଲେ 3 ଜଣ ହେଇଗଲାନି କି?
କେମିତି?
You are one,
all
your
three-
2 other petitioners, so become 3. All the petitioners are there.
We can carry one associates with us. That is for the purpose.
All right, 3 advocate associates. All right. Whose names will be provided in advance
Yes.
to the AGAs, the 2 AGAs, who will in turn communicate it to the local administration.
Can we be permitted to take our associates?
All right. All right. All the 5 advocates are permitted to be accompanied by 1 associate advocate each, whose names will be given in advance to the local administration. All right. I'm really hoping there'll be complete peace.
My lord, I promise before your lordship, the entire episode will be videographed and it will be
All
given
right.
to you.
All right. All right.
Your Lordship.
Sorry, the collector's affidavit will also indicate the details of the previous public hearings which purportedly took place in the village and whether any EIA clearance has been accorded for the project as of date. Yes, please.
Sorry, sir. I know there's a vehement argument out here to ensure that, you know, I do not participate in it.
We've not said anything.
Sorry,
We've not
sir,
said
sir.
anything. I
So
think
you
you're
never
missing the
allowed
point
me
here completely.
You-
The order has not said anything about that.
Yes, sir.
Yeah.
That's what I'm trying
So
to
you
say.
please leave
I'll
it at that.
definitely be there, despite.
You will be definitely be there.
I'll
Your lordship
definitely.
can see what she is submitting.
Yes.
Despite this order, she is saying that I will be definitely in that meeting.
Yes.
Then there will then administration will not allow him because
So
of this
am
order.
I, as a woman, am I such a big menace that he cannot bear me in the meeting?
Your lordship will go through my report I have stated in. So your lordship
So
has specified that only committee members, they are associate advocates. That's all.
We leave it at that, Ms. Barpanda. We just leave it at that. We'll address this issue, like I said, in sequence. Right now, our focus is to make sure the villagers speak fearlessly. All right.
And I'll be.
And
there.
with the order of a high court, that should happen. All right. We'll address this issue definitely. All right. Okay.
Thank you, sir.
All right. All right.
Supplementary list item number 22. Supplementary item number 22.
I prepared a some.
I have also prepared a short note.
The subject matter of the case, my lord. Say denial of.
Typographical error.
Yes, madam.
Written note, you've said, instead of argument, you've said agreement.
No, date chart I've given. I've given a date chart.
No. Written note of?
Oh, sorry, sir. Sorry, sir.
Yes. So
Sorry,
we'll take
Lord.
it at the end of the board. So we'll take it at the end of the board.
End of.
It's going to take some time. We'll take it at the end of the board.
Problem.
Yes.
Supplementary item number 24.
None appears to the petitioner. Dismiss the non-possible.
Supplementary list item number 25.
Item 25.
25 here, Lordships. What we challenge here is.
Just a minute, I am just fetching. I am seeking time, my lord. Can Lordship give some time because I have seen that counter and rejoinder file is a old file. The additional FT also filed by my learned friend. I have gone through it. Lordship give at least 3 weeks time because they have challenged the virus as well as.
All right. At the request of Mr. P.K. Padi, ASDI. who needs some more time to examine the matter based on how urgent is this? Not very urgent.
Actually, this matter, what really has happened is, Your Lordships, this is regarding the Legal Metrological Act, 2009. What the Act gives to the citizens, exactly the central government takes it away through its rules. What is done is completely delegated the essential governmental functions of verification, stamping, as well as giving them powers to a private body only with the payment of 10,000 rupees. Completely opposite to exactly what our state government, we'll be proud of the rules that our state government has made in order to ensure that that kind of vigilance is maintained. And definitely the court will understand that this aspect actually is very important to not to have any chaotic situation in any country. It's way back civilization that the sovereign used to maintain a control about these standards. And exactly the opposite is what the central government has done. And in fact, what it has done is the machinery, the collector, which is the state machinery, completely has been, made useless. The entire thing, how can they just...
All right, 4th May.
So it's actually a grave situation.
All right, 4th May.
Mobilize, man.
Supplementary list item number 26.
Lordship, the petitioner has already been promoted. The matter of
infractors. Counsel the petitioner states the petitioner is rendered infractors. This post of
Supplementary list item number 27.
27 infractors.
Infractuous. This post of.
Supplementary item number 28.
None
My lord's item number 20. No, Your Lordship, there's no instruction in this case.
No instruction.
I like to withdraw.
Okay. Seeks to withdraw, dismisses, withdrawn. All right.
Supplementary list item 29.
Item 29 on behalf of Mr. Mishra, my lord. I may be permitted to place, my lord.
Yes.
My lord, Lordship, kindly have a glance, my lord, towards the order dated, my lord. Order number 6, my lord, 20 July 2016, my lord. The second paragraph, my lord, considering the fact that we direct that the matter should be investigated expeditiously and taken into his logical conclusion as early as possible. We further direct that the opposite partner shall personally look into the matter and file his personal affidavit with regard to the progress of the case by next date.
There's one more order after that, sir.
Yes, my lord. And thereafter, my lord, that affidavit they have not filed and not served also copy to me, my lord.
Kindly see my affidavit at flag Q. That is affidavit dated 38/2016. Paragraph 3 and 4, my lord. 4 persons were arrested. Well, after
one is in judicial custody.
Yes, 4 persons were arrested.
Yeah.
1 person was in judicial custody in connection with another case, and another accused person has died in the meantime.
Right.
And
what has happened to the case?
This was filed in the year 2016. Only charge sheet has been submitted.
All right. You see, it appears that from the affidavit dated 30th August 2016. Of the 6 accused, 1 was in judicial custody and 1 had died in the meanwhile. 4 have been arrested on 19th August 2016. They stated that a charge sheet has also been filed. It is expected that the further steps will be taken in due course. The petition is disposed of.
A copy of the affidavit I have not been received.
All right. Copy of the said affidavit be served on counsel for the petition.
Obligement.
List item 30.
None appears dismissal not possible.
Your Lordships, am I audible, Your Lordship?
Yes.
Your Lordship, item 30, Your Lordship, the matter has become infructuous.
All right. The petition has been rendered infructuous. It's disposed of as such.
Supplementary list item number 32.
None appears dismissal not possible.
Supplementary list item number 33.
You have been noted.
Item 32, am I audible to your lordship, my lords?
Yes.
May I be permitted to be on virtual mode, my lords?
Yes,
In this case, my lords, in this case, the cause of action as in today doesn't exist.
All right. Cause of action does not survive. It is disposed of as such. All right.
Supplementary item 33.
Deeply.
None appears dismissal not possible.
Supplementary list item number 34.
My lord, I may be excused for item number 33.
33, dismissed.
For 33, as no further cause of action subsists, the case may be not pressed.
All right. No cause of action subsists.
Item 34.
Item, pardon, item 34. So by the counter affidavit they are filed in the meantime. Copy may be supplied thereafter. Counter affidavit.
Counter file, but
Copy of the counter affidavit be served on counsel of the petitioner within 3 days. Rejoinder of any before the next.
Both the items.
List on 28th June. Both matters. Yeah.
Yes. Supplementary list item 35.
May I please, my lord? My lord, kindly have a glance to your lordship's order dated 24/6/2021. Even if after completion of 1 year of period of filing this contempt, this justice delivery system is still struggling for a piece of land for construction of its building of Civil Judge Senior Division at Konark, my lord. Kindly have a glance to the order.
35.
35.
Contempt 1362.
We are Gangpur hockey.
I think that was listed before some other bench. I have just argued and come up before this.
Sorry, my lord.
It was report number 3, my lord.
I may pardon, my lord. I may pardon. I am there in item 24, but could not hear. That's why it was even dismissed for non-appearance.
All right, you tell us what it is.
I was there, man.
All right, what is it? Tell us the matter.
This is regarding cancellation of lease under section A7, 7A3 of OGLS Act. Last occasion, your lordship has directed the State Council to take the order of WPC number 9449 by 2093, my lord. This record is not traceable as noted in the list, my lord.
So tell us what the matter is about.
My lord.
What is this matter about, sir? Tell us.
My lease has been cancelled under section 7A3 after expiry of 14 hours. Where the law provides that after 14 hours, no 7A3.
Not hours, sir. 14 years must be.
14 years, my lord. And to that effect, I am also submitting some decision of our High Court, my lord, that after 14 years, no proceeding can be initiated. I have also quoted the provision in my para 8, my lord, that after expiry of 14 years, no revision is maintainable. I am also submitting some decisions of our High Court covered by your lordship judgment.
This is that Bhubaneswar land fraudulently lease was granted and subsequently cancelled by the ADM under section 7A3 of the OGLS Act. And here is the petitioner was very much hard by the ADM, and after hearing the order was passed. There is no case of violation of principle of natural justice. And if your lordship will go through the impugned order, para 7, internal page 3.
This is not a case of fraud, is it?
Yes, I'm just placing because para 7, internal page 3. Further, during course of hearing of the case, it was came to my notice that the OP has migrated from other region of the state, so he is not a permanent resident of the village. The ASO Sri PC Mahapatra, who was entrusted with the field inquiry, has reported that the OP could not identify the exact location of his land. Pieces of land were leased out of so and so. Inquiring officer had reported that one Ramadas Agrawal has put pillars over the land in plot number 257. There is also a house constructed inside it. This means that lands have been purchased from the lessees and estate developers have converted the lands given to agricultural purpose as house sites. The lease was granted for agricultural purpose. They have parted it in favor of builders, and without conversion, they have constructed this lease is an agricultural lease, para 9. The land leased out should have been put to cultivation. So the implied condition of the lease has been violated. As such, I don't agree to the argument of the learned advocate that the lease is an unconditional one. Rather, in the instant case, the leasehold has not been used for the purpose for which the lease was actually sanctioned. Thus, the character of the leasehold land has undergone a complete change. The lessee did not possess the land at any time. There was no demarcation of the land at any time, nor the OP has taken delivery of possession of the same, and even the OP is not aware of the exact location of his land. The inquiring officer has also reported that the lessee has not produced the up-to-date rent receipts. It is pertinent to mention here that being convinced by material irregularities in procedure and legal infirmity in the main lease case number so-and-so, the ADM Bhubaneswar in his order number so-and-so, in revision case number so-and-so, has cancelled the said lease. It is therefore natural that this lease case, which was analogous, had along with the above mentioned main lease case, should have been cancelled as it suffers from similar defects. So from the same khata, other lease cases were cancelled by the ADM. That is the observation in the impugned order. In view of the facts mentioned above, I come to the conclusion that the settlement of government land in favor of the OP suffers from material irregularity in procedure as well as legal infirmity, and the lease has been granted in contravention of the provisions of the OGLS Act without following any of the mandatory provisions of the. Therefore, the lease has no force in the eye of law from the date the same was granted. I therefore set aside the order dated so-and-so and the Tahsildar setting an area so-and-so. So these are the infirmities which was noticed by the ADM, and pursuant to which the ADM has exercised its jurisdiction under section 7A3. My response submission is that there is no legal infirmity in the order. It is a fraudulent transaction. The person not belong to that area, he is an outsider, and the lessee is an outsider. He was never given delivery of possession. And in the meanwhile, the last but not the least, I would like to submit with your lordship. This is within that smart city area, and it is not to be used for agricultural purpose under any circumstances. And the lease cannot be revived because the purpose for which the lease was granted cannot be used by the.
Correct. Yes, please.
What my lord senior stated that from the same khata, I have submitted a judgment that is Gopal Das Raghural versus State of Orissa, my lord. It is also from the same khata number 95, my lord. There, this honorable court interfered and stated that at no circumstances after 14 years, the lease can be cancelled, my lord. I have given 3 judgment of this honorable High Court, my lord. That order passed in the public interest litigation can never have the effect extending the period of limitation.
So what will happen, Mr. Mohanty, is only this: the status quo is already changed. There are some constructions on it already.
No, construction it is there so far only pillars. There is no permanent
By now,
construction.
everything would have happened, sir. There is a stay granted by this court.
There is no permanent construction, my lord. It cannot be because it is within the very.
No, it can't be used for agricultural purpose anyway. It's not going to be used for agricultural purpose anyway.
That is
because the law seems to be very clear. 14 years.
But in case of fraud, your lordship knows the limitation may not stand on the way.
This is not the narration is not that it is fraud.
Yes, that is tainted with fraud.
This seems to suggest that this Purna Chandra Pradhan. Have you seen that?
My lord?
This decision. You have given him a copy?
Yes, no. Lordship may fix it for judgment. I will cite some decisions if I find that. But so far as that 14 years is concerned, that should not be made applicable in case there is any fraud in.
No, that was argued here in this case. This Purna Chandra Pradhan.
We will find out some subsequent judgments after this. Lordship may give me 1 day time. Lordship may fix it for judgment. We will only cite citations.
No. He says, no doubt the date of deduction such fraud will be the relevant date starting point.
Gopal Das tapar pradhan. Another recent judgment is also there, 2019 supplemented to OLR. But I could not able to give because 2 pages are missed from my book. Otherwise I get the copy. Recent judgment of 2019. OLR. Everything has been discussed about that PL method, everything has been discussed. 2 pages are missed in my book. That's why 150, 253, 2 pages are missed. So I got it xeroxed. Madam? Given what?
The proceedings here were started after 42 years.
42 years.
Here
And this is
25
also
years.
resumption proceeding.
No, it is also that.
No.
7
Here,
years.
when was the lease granted here?
Release granted in
98.
1973.
No, 98, sir. 1973. Correct. Correct. So it's 25 years.
After 25 years. In Gopal this case, I have given is also in 25 years in the same khata, my lord, same date, everything is same. Same 95 khata.
No, but when was the date of detection of the fraud? That's the point. Yeah.
Lordship may call for the records that will be.
Your Lordship may kindly see Gopal Das case, last paragraph. Applying the above proviso, we find that the impugned order suffers from the rigor of both the aforesaid provisos. Accepting the contention of Mr. Mahapatra, we hold that the impugned order dated so-and-so passed in release division case number so-and-so by the ADM Bhubaneswar is without causing any notice to the petitioner who is the affected party and further. So it is a case.
Subsequent para.
Subsequent.
Subsequent like 14 years.
No, but also 14 years.
14
Yes.
years.
But the mainly case was remanded.
No,
And order was quashed on the ground
No, but
that it was.
here, I don't know whether the word fraud is used at all.
Now the fraud word may not
lot
be
of the
used,
words are irregularity, infirmity, that kind of a thing.
but the grounds which has been taken in the impugned order, your lordship can
No, it's only
visualize.
that the purpose has changed. It's not any fraud. That's not what is pleaded here. I think it's not, there's no indication of any fraud here. Because in that Purnachandra Pradhan, they have said that when there is no finding of fraud, you can't just extend the period of limitation.
And another person is in possession who is named as
Yeah,
Ramdas
that's right.
Agarwal.
That's all. It doesn't have, say that this is fraudulent.
Now, one thing the petitioner must come with clean hands, whether he is still in possession or still he holds title or he has already transferred it to Ramdas Agarwal. Because I doubt that
that's a valid point. Are you still in possession?
That this Ramdas Agarwal must have purchased the
So
land
far as
from you.
Ramdas Agarwal is concerned, but the original Liji has filed this application.
No. So
No,
what is
maybe
he? Is he in possession of the land? If he still, or has he sold it?
I am in possession, what I have stated,
No.
my lord.
No. Stating that in 2010 is not the same thing as 2022.
So that I have taken instruction whether it
No,
is.
you ask him to file an affidavit.
My
He said the
lord.
petitioner will file an affidavit
My lord.
within 2 weeks indicating whether he's still in possession of the land in question.
My lord.
And who, if
And
not-
about the status of that Ramdas Agarwal.
No, and if not, who else is? And in what circumstances? I think give it back to him, because it'll get lost if you tie it up. List on 30th March.
Supplementary list item number 35.
Item number?
None is
Wait, please. Lordships, we want to withdraw this.
All right, council petition, to withdraw this petition. Dismiss. All right.
Supplementary list
Deep
item number
preparation.
36.
I received a copy of a counter 2 days back, 1 week time to file the reply to the counter.
All right, rejoined to be filed for the next date, 9th May.
Supplementary list item number 37.
Yeah, please, my lord. This is the canal matter. This is the Nayanjori matter that was in the list last time. I had in the previous date I had sought an adjournment, but before that I had submitted an affidavit with photographs of the construction. And
yes, Mr. Monty, you're there in this.
Is no counter is filed by us, but the private opposite party has filed the counter affidavit.
No, but on Nayanjodi land, concrete bridge is there.
The allegation is that non-jury land is being encroached upon by private individuals and construction is being made.
No, you had agreed to file an affidavit before 29th.
On 23/8/2021.
You filed this affidavit?
No, ma'am.
The state is yet to file an affidavit in terms of the order dated 3rd November 2021. Last opportunity to do so on or before 22nd April 2022. List on 29th April 2022.
Supplementary list item number 38.
Interim order to continue.
Item 38.
May I, Lords? Lords, so have issued notice on 27/1/22, my lord. No counter has been filed, my lord.
हम कुछ कॉरियर नहीं, but देखिए लो आप
30. Actually, here in this case, my lord, the petitioner, the displaced families residing in the village.
Let him file the reply, sir. Reply be filed within 4 weeks. We joined up for the next. 25th April.
27th April.
Supplementary list item number 40.
May I please also. The matter related to Sisuvan on 29/4/2021, Lordship directed to file State Council to file an affidavit. On 14/9/2021, they filed an affidavit. We are disputing the affidavit filed by the State Council. To that effect, the Lordship directed us, a committee, to inspect the Sisuvan. Because in their affidavit, they filed the documents that they have given the agreement for sanitation and clean of the Sisuvan. Then we visited, we given our report also in pen drive and photograph. It is apparent from the photograph and videos that all the money are wasted by the government. Nothing has been done as filed by the affidavit on 14/9/2021, my lord. They have made an agreement, annexed the agreement with the the persons who take the tender of sanitation and cleanness. But absolutely, it is not my submission. This is already evidence on record in videography and photography. And also I submit accordingly the report that all the money is wasted by the as well the Sisuvan or the government, my lord.
No. What about the cleanliness and orderliness? It's bad. What about this
mud
situation on the ground?
My lord.
What about the cleanliness, the orderliness?
My lord.
No. What did you find, sir?
I've given in my report and videograph and photograph also.
Yes.
Because all the rooms, corridors, roads, drinking water, all are of mud, my lord. Absolutely.
All are what?
Mud.
Immunity mud, there's a side mud.
Mud.
नहीं तुम 14/2 रो affidavit टा देखुचो
नहीं
mud means what?
देखो 14/9
in 14/2/2022 I filed an affidavit in this case, lord.
Not serve the copy, my lord.
It means it's iron water, my lord. It means kitchad, my lord, kitchad.
Oh, okay.
The committee submitted a report.
Detailed submit report ward wise and also the ICU, COVID ward, surgical ward, my lord, where we indicated that the, suppose that dialysis room, the 2 dialysis beds of pediatric patients are available, the beds and rooms position is good. Dialysis and water condition is good, but no
Who's the
dialysis
superintendent,
patient-
sir? Who's the superintendent of the home?
So that hospital, Millers.
Huh.
Yes, she has only filed the affidavit, Millers. Pursuant to the report of the committee, we have responded, filed Millers a detailed affidavit on the 14th of this month, Millers. There, in most of the cases, we admitted what the committee has stated. And we have said that we are taking corrective steps, Millers. Not that we are.
For every photograph submitted by them, can you show us a corresponding photograph that it has been set right?
I've already given my lord.
You have the photographs, correct?
Them also.
The committee is.
Yes, committee's photograph they had given at that time, Millers.
No. Now with their report they've given photographs. Sir.
No, not recent. After this 14-2, Millers, they have not filed any
Not
affidavit.
after 14-2.
No.
They have given photographs with their report.
Yes.
Yes, ma'am.
Can you show us corresponding photographs of the same locations?
No, Millers, I have not filed, Millers.
No, you show us corresponding
I will
photographs of
come
the
up.
same location to say that it is set right.
I will come up, Millers. I will come up, Millers.
Mr. Samantra, AGA states that he will file with an affidavit of the, what do you call him, superintendent?
Superintendent of Millers.
Of Sishu Bhavan, photographs that correspond to the photographs of the committees enclosed to the committee's report, advocate committee's report, which would show that the situation at particular locations has improved. The affidavit will be filed at least 1 week prior to the next date. 30th March, sir.
No.
What my learned friend submitted, that he is already filed an affidavit. A copy down the.
I will give a copy, no dispute. If you not be given, I will give you a copy.
Or the affidavit filed by the learned superintendent of Susuvan. Copy may kindly be served so that we can also.
You have a right, I said, I will give it to why you
My lord,
repeating.
my
I
lord.
said, you have got a right to get it.
My lord,
Right.
One pastor matter, supplemental list, item 22.
Can you take up an orders, my lord, in spite of hearing? May I pray, my lord, item 40 can you be taken up for orders, my lord?
Sure, sir, sure.
My lord.
All right.
Oblige, my lord.
Item number 22.
So we have it on some other day. List on.
Next week.
Not next week, sir. 5th May.
I am permitted to correct the typewriter.
Yeah.
Sorry.